To mention, my lord, I am mentioning for extension of interim order, my lord, which will be expired on 30th August 2025.
30th August. Passed by?
Passed by your lordship.
Tomorrow to be mentioned.
Great, my lord.
Give notice to other
Yes,
side.
I have already made notice. Again,
Extension of interim order. All লিখে রাখো। ঠিক আছে?
Contem application, lordship.
My order.
Yes, lordship.
5th December.
No, my lordship, kindly urgency is there, lordship. My egress and ingress blocked by the private respondent.
December. December 5.
I crave to mention a matter for release from the lordship
Contempt application 5th December.
for release from the lordship list.
Release. Why?
Lordship, those are my instructions of my client, and those are the instructions of my client as the matter has not been heard for a long time, and the urgency is that I'm not receiving any salary. My salary has been
Hearing matter.
Yes, lordship.
Hearing or motion?
Hearing. It has been heard.
To be mentioned, bracketed release. Bracketed release লিখে রাখুন. To be mentioned tomorrow. Bring other side.
Lordship, I will serve them in office.
Give the slip.
Yes, lordship. Once again, I will give the slip.
Give the slip. To be mentioned tomorrow. Yes.
Lordship, item number 1. This matter was mentioned yesterday before my lord. This is a writ petition assailing an RTI reply.
Why RTI? Wow. It is to be mentioned.
Lordship, because Lordship, my lord does not this matter rightly had to be filed under 9, your lordship.
Ash. MS, your name?
Lordship, Miss Majumdar, Shreyangshi Majumdar.
Your name?
Shreyangshi Majumdar. Shreyangshi Majumdar.
Shreyangshi
I'm
Majumdar.
appearing-
Take the microphone. Take the microphone.
Lordship, I'm appearing for the Union of India.
Lordship,
Shreya-
I'm praying for liberty to make corrections in the
Shreyangshi Majumdar, landed advocate for the petitioner, comma, submits that, comma, this writ petition pertains to residuary determination, comma, group 9, bold, of the classification list. What is your name?
Shurobita Bishwas. Shurobita Bishwas.
Shurobhita
B, Lordship.
Shurobita Bishwas, landed advocate, appears for Union of India. Likhun, due to it, paragraph, due to want of determination, this petition is directed to go out of the list of this court and to appear before the appropriate court. Paragraph. Records are directed to be sent before the appropriate court forthwith. Paragraph. Liberty is granted to the petitioner to correct the presentation form and wherever it is required in the writ petition. Next.
For the respondent transport corporation.
Why?
So I'm appearing on behalf of the petitioner.
What is the correction?
Your lordship, name of the petitioner.
It should be
It should be Devatas Ghosh in place of Chandeshwar Singh.
the writ petition appears under the heading to be mentioned today at the instance of the petitioner for causing the typographical correction which is apparent on the face of the order dated August 5, 2025. So the name of the petitioner was wrongly typed out as Chandrasekhar Singh, Chandreshwar Singh. The same should be corrected and read as Debotosh Ghosh.
Yes, Lordship.
Debotosh Ghosh.
Yes, Lordship.
As reflected in the cause title of the original petition. Paragraph. The rest of the order remains unaltered and without any modification. Mr. Your name?
Shayan Banerjee,
Shayan Banerjee, learned advocate, appears for
Transport Corporation.
CS,
WP
with
West Bengal
WPTCL.
TC.
Item number 3 and 4, my lord, Mr. Partho was appearing. He
Yes,
engaged,
proceed. No.
engaged in courtroom number 8, my lord.
Then after vacation. Either you proceed or you after vacation.
But only, my lord, may I take an opportunity, my lord, to show you also one more judgment, my lord, one judgment, my lord, but so that I can continue with within that Mr. Pathakos will come. But this is, my lord, 2014 9 HCC
329.
329. But I am giving them a copy also, my lord.
নোটটা কোথায়? ওইতে। আচ্ছা। You take down the citation.
But I have given him a copy. Yeah, my lord, this case
2014.
2014, my lord. Yeah, my lord, why I am showing this, my lord, in this matter, my lord, this question of
21 Yes.
the question of cause of action, my lord, and my lord, the power of High Court to issue certain writ, my lord, within jurisdiction, my lord, has been detailedly described, my lord, after going through several judgments. 2 or 3 judgments I have already shown, my lord. There are 2 or 3 judgments mentioned in this, my lord. I want to show that also. First, my lord, if you lordship,
Paragraph.
first, my lord, if you also take up, my lord, para 7 first, my lord. What was the question in this matter, my lord, to show that, my lord? The short question.
Paragraph.
7 onwards, my lord. 7 onwards. 7, my lord. The short question which falls for consideration is in this fact is that the present case is that of where the Patna High Court is correctly in taking view of having no jurisdiction to entertain a writ petition. The answer of the said question, we would like to consider the provision of Article 226 of Constitution of India as it stood prior to amendment. Originally, Order 226 of the Constitution of India read as, but it has been stated. But if you also want, I can place that also. Nothing anything in this Article 32 of High Court shall have power.
Where?
My lord, para 7, my lord, para 7.
7.
First, my lord, what was the condition, and thereafter what has happened? My lord, before
para 7, the quotation is there, 226.
Yes, my lord, 226 quotation, my lord.
Thereafter,
my lord, the amendment has taken place, my lord. The power, if you also see 7 only, my lord, 2, my lord, the power conferred, clause 2, my lord, the power conferred on High Court by clause 1 shall not be in derogation with the power conferred of the Supreme Court
that is not there. Now the insertion comes to 26, 2 is the jurisdiction.
My lord. Now, my lord, kindly see, my lord, I am saying, my lord, that everything has been considered in this judgment. To show that, my lord, I am just showing that, my lord. Now, my lord, if your lordship sees, my lord, para 10 onwards, my lord, I have already stated, my lord, from other judgment, that state of Rajasthan versus Swastik properties, I have stated it is discussed over here, my lord. Now, next, my lord, para 11 also, my lord, oil and natural gas commission, Utpal Kumar Basu, my lord, that is also stated, my lord. Previously, I have shown to your lordship. Now, my lord, kindly comes to Kusum Ignis, has also has been shown. That has also been shown to me, my lord. Now 13, my lord, kindly see, my lord, this is judgment which I want to place, my lord, from 13 onwards. The Union of India versus Adani Export Limited.
Adani you have placed.
It has also been placed. Then I am not placing that again, my lord. Then my lord, kindly comes to page 14, my lord. Para 14. Om Prakash Srivastava versus Union of India. The answering a similar question in court observed that on a plain reading of clause 2 of Article 226, it is significantly clear that the High Court can exercise power, issue direction, order or writ for the enforcement of any of the fundamental right or for any other purpose if the cause of action as relation to which it exercised jurisdiction, notwithstanding that the seat of the government or the authority or the residence of the person against whom the direction, order, or writ is to be issued is not within the said territory. In para 7 of the court observed that the question.
Where you are reading?
My lord, I am reading para 14. My lord. Para 14.
Para?
14.
1
4, my lord. Next page, my lord. Page 339, internal page. First paragraph.
The question whether.
The question whether or not cause of action wholly or in part for filing a writ petition has arisen within the territorial limit of any high court has to be decided in the light of the nature and character of the proceeding under Article 226 of the Constitution. In order to maintain a writ petitioner has to establish that a legal right claiming by him has prima facie either been infringed or been threatened to be infringed by the respondent within the territorial limits of the court jurisdiction, and as such the infringement may take place by causing him actual injury or threat thereof. Now, my lord, para 15, my lord, this court for para 15, my lord, this court while considering the scope of article.
Yes.
Para 15, my lord, this court while considering the scope of Article 226(2) of the Constitution, particularly the cause of action in is maintaining a writ petition, held that.
Where?
My lord, para 15.
Particularly the cause of action in maintaining a writ petition held that.
The first question that arises for consideration is whether the Andhra Pradesh High Court was justified in holding as the seizure took place in Chennai, Tamil Nadu. The appellant should not maintain the writ petition before it. The High Court did not examine whether any part of cause of action arises in Andhra Pradesh. Clause 2 of Article 226 makes it clear that the High Court exercising jurisdiction in relation to the territory within which the cause of action arises, wholly or in part, will have jurisdiction. This would mean that even if a small fraction of cause of action that bundle with the fact which give the petitioner a right to sue accrued within the territory of Andhra Pradesh and High Court and the state within which the jurisdiction. Normally, we would have to set aside the order of remitting the matter to the Honorable High Court, for the decision on merit, but for the prospective submission of the appellant who appears in person or various dates for hearing 2 or 3 this I think I am placing it. Firstly, it will be clear that the maintaining object of the petition was to ensure that later in future passages like him or not put in unnecessary harassment or undue hardship at the airport. But I think this is related to that case. I don't want to place this. Now, the important part which I want to place after taking all this jurisdiction, this judgment, the court has held, what is the submission? Para 16, which is most important.
16.
Regards had to be decided. Discussion made herein above. There could not be any doubt that the question whether or not cause of action wholly or in part of filing of writ petition has arisen within the territorial limits of any high court has to be decided in the light of the nature and character of the proceeding under Article 226 of the Constitution. In order to maintain a writ petition, the petitioner has to establish that a legal right claimed by him has been infringed by the respondent within the territorial limits of the court's jurisdiction. Now, in this case, my lord, what is their prayer? Their prayer is, my lord, is to stay the charge sheet, my lord. If your lordship again comes to the prayer, my lord.
Yes.
No, here, my lord, the writ in a nature of mandamus commanding the respondent authority, including their man and agent, subordinate, servants, successor in office, to stay the disciplinary proceeding and the inquiry initiated by the respondent authority arising out of charge sheet. Charge sheet, but the details are given dated 6/2/2025 till the criminal proceedings are concluded forthwith. Admittedly, charge sheet has been issued in Mukma. My lord, it was initiated in Mukma. Offense has been over there, my lord. I am just in the course of repetition, I am saying that, my lord. Here, my lord.
Except the sanction of prosecution, everything outside.
Yes, my lord. The sanction, my lord, has not been challenged in this repetition. The sanction that saying that the sanction given by the headquarter is bad has not been challenged, my lord. Nor, my lord, the venue has been challenged that no, I will not go over there because it has arise over here, my lord. It's here, my lord. The integral part of the cause of action is this, my lord, that he have challenged the charge sheet, my lord, which has arisen within jurisdiction of Mugma, my lord, within the jurisdiction of Jharkhand, my lord. My lord, that is my submission, my lord. So I just want to show to that, my lord.
Yes, proceed.
My lord, kindly give me a short passover, lordship.
No question of short passover after vacation. This
My
is
lord,
not
I'm
done.
not paying for any
In whose
accommodation.
instance it has been fixed today. At his
Lordship,
instance.
he engaged in courtroom number 8, item number
No,
1,
no.
your lordship.
Either
It's on
you
his leg.
proceed or very well, don't proceed. I don't mind, but it will be after vacation. Court doesn't have that much of time before vacation. Everybody should be granted opportunity of hearing. Yes. Proceed. Yes, sir. What is your name?
Devashish Das.
Devash. Proceed. Yes.
My lord, may I permitted to submit your lordship 2004
Yes.
6 SCC 254.
2004
2004 6 SCC 254.
25. Yes. What are the paragraphs?
Paragraph number 6,
এটা রাখো
6,
ওই
7,
ফাইলটা আছে তো বাস ওটা পড়ে দেবে আগে আমি দেখিনি পিটিশন
paragraph number 6 to 10 and 25.
রিড
My lord, paragraph number 6, cause of action implies a right to sue.
টেক দ্য মাইক্রোফোন ইয়েস
Cause of action implies a right to sue the material facts which are imperative for the shooter to allege and prove constitute the cause of actions. Cause of action is not defined in any statute. It has, however, been judicially interpreted inter alia to mean that every fact which would be necessary for the plaintiff to prove if traversed in order to support his right to the judgment of the court. Negatively put, it would mean that the everything which, if not proved, even the defendant and immediate right to judgment would be part of the cause of actions. Its importance is beyond and doubt. For every actions, there has to be a cause of action. If
এই
not,
লাস্ট জাজমেন্টটা ইয়েস রিপ্লেসমেন্ট
if not, the plaint or the writ petition, as the case may be, shall be rejected summarily. Para 7. Clause 2 of Article 226 of Constitution of India reads thus: 226(2) power the conferred by Clause 1 to issue directions, order, or rights to any government authority or person may also be exercised by any high court exercising jurisdiction in relation to the territory within which the cause of actions wholly or in part arise for exercise of such power, notwithstanding that the seat of the government or authority or the residence of such person is not within those territory. Para 8. Section 20C of Code of Civil Procedure reads as under: others choose to be situated where the defendant reside or cause of actions arise, subject to the limitation aforesaid, even suit shall be instituted in a court within the local limits of whose jurisdictions. Then, my lord, para 9. Although in view of the section 141 of the Code of Civil Procedure, the provision thereof would not apply to the writ proceedings. The use in section 20C of the Code of Civil Procedure and clause 2 of the article 226 being in perimetrial, the decisions of the court rendered or interpretation of the section 20C CPC shall apply to the writ proceedings also. Before the proceeding to the discuss the matter further, it may be pointed out that the entire bundle of the fact pleaded need not be constitute a cause of actions, as what is necessary to be proved before the petitioner can obtain a decree in the material fact. The expression material fact is also known as integral fact. Para 10, Lordship. Keeping in view of the expression used in clause 2 of the article 226 of the Constitution of India, indubitably, even if a small fraction of cause of action occurs within the jurisdiction of the court will have the jurisdiction in the matter. Then, my lord, kindly come to para 25, Lordship.
Para
25.
25. You're doing well. Keep it up.
Lordship.
Doing well. Keep it up.
In the said decision is an authority
Wait,
for
wait, wait. Let me go to 25.
Lordship.
Yes.
The said decision is an authority for the proposition that the place from where an appellant order or an revisional order is passed may give rise to the part of cause of action, although the original order was at a place outside the said order. When a part of cause of actions arise within one or other high court, it will be for the petitioner to choose his forum. My lord, may I permit to submit a lordship 2014?
Wait. 2000?
14.
Yes. 9 SCC?
9 SCC 329.
329. Which your learned friend has also submitted. Yes. Paragraph?
Paragraph 12, your lordship.
12.
In Kusum ignores the court elaborately discussed clause 2.
Wait, petition. Paragraph
12, your lordship.
12. Yes.
In Kusumignon and Alloy Limited, this court elaborately discussed clause 2 of the Article 226 of the Constitution, particularly the meaning of the word cause of action with reference to section 20C and section 141 of the Code of Civil Procedure. Although in view of section 141 of the Code of Civil Procedure, the provisions thereof would not apply to the writ proceedings, the phraseology used in section 20C of the Code of Civil Procedure
He's doing well.
and
Don't
clause
disturb.
2 of Article 226 being in perimetrial, the decision of the court rendered or interpretations of the section 20C CPC shall also apply to the writ proceedings also. Before proceeding to discuss the matter,
This sentence you are just now starting. Before proceeding, read very carefully, slowly, boldly.
before proceeding to discuss the matter further, it may be pointed out that the entire bundle of fact placed need not constitute a cause of action, as what is necessary to be proved before the petitioner can obtain a decree is to be material fact. The expression material fact is also known as integral fact.
Yes. So, let's say there are 20 facts jumbled up. The bundle of facts, right? All such facts are not necessary. What is necessary? The integral fact, the material fact, right? So, what according to you is the material fact and why which arose within West Bengal? In your case, in the facts of your case.
My lord, the authority, Eastern Coalfield Limited, it is in West Bengal, your lordship. My lord, the order issued from West Bengal.
Which order, sir?
My lord,
You do in your own way. Don't look at your senior.
lordship, the sanction.
I have to fire, then I will place the gun on your shoulder of your senior, not on yours. Which page, sir,
My lord,
according to you, is the material fact? Show me.
my lord, page 48.
40,
48.
sorry,
48.
40. Yes, I'm 40, on 40.
Order, this is an appointment, lordship. Sri,
ওই বাহাদুরকে বলো তো এখানে ওয়েস্ট পেপার বক্সটা কোথায় গেল? যেখানে কাগজ কাগজ কাচড়া ফেলা হয়, আসতে বলো উপরে। হ্যাঁ, ইয়েস।
lordship, in Sri Rigan Kumar Sethi, manager,
হ্যাঁ, হ্যাঁ, which page, sir? Page 48.
second paragraph,
Page 48.
lordship.
Yes.
Second paragraph, lordship.
1 second. এই এটা রেখে দাও পিটিশনারের ফাইলে। Yes, read.
Second paragraph, lordship.
Read loudly.
Sri Rigan Kumar Sethi,
Sri Ragan Kumar.
Ragan Kumar Sethi is also hereby appointed as management representative to present the case on behalf of the management in the inquiry mentioned above. The inquiry should be concluded in less possible time, providing providing nature justice to both sides as per the uh, confined standing order of ECL.
Take the microphone, take the microphone.
Lordship.
Inquiry should be concluded in last
Possible time.
No, last one. Least.
At least possible time.
Then
providing nature justice to both sides as per certified standing order of ECL.
yes. So according to you, page 48 is a material fact.
And your lordship. And your lordship, next page, your lordship.
How this was issued from where?
Shampur B. Colliery, Lokshimata Group of Mines.
Huh? Are you take microphone.
Shampur B. Colliery, Lokshimata Group of Mines. Agent, your lordship.
Dhanbad. Issued from Dhanbad. Dhanbad is not where? Within or outside?
Outside, lordship.
Yes. So according to you, this is a material fact.
Lordship.
According to you, this is a material fact.
Yes.
You're doing well. Why you are getting shy? Make your submissions. You're doing well. Jump. Yes. Then?
So.
So according to you, this is a material fact.
Lordship.
Sir, even if it is a material fact, it is issued from Dhanbad.
Lordship.
So outside.
Yes, your lordship.
Next. Wait. Which further document according to you is a material fact? Show me.
I'm raised, my lord. Let my senior start, your lordship.
You have done well. Keep it up.
My lord, may I quickly, my lord, show some few documents, my lord?
No, not few documents from writ petition.
Yes.
Yes.
First as page 28.
28.
My lord. Initially, the cause of action arose by, my lord, allowing the authority to issue the charge sheet. This is a cause of action to the cause of action. Now, if your lordship kindly see, my lord, the serial number 6 of page 28. Letter number such and such issued by Subroto Dasgupta, General Manager, PEE, ECL Headquarters.
Correct.
This was the letter genesis of the, my lord, issuance of the charge sheet. This is the sanction letter,
Page,
For-
page.
page 28, my lord.
28.
My lord.
The one he has shown. No, he has.
No, he has not
20
shown.
No, 20. Where is that letter?
No, letter I have, because letter they have not supplied. I repeatedly asked them to supply. They have not supplied the letter. Even they have not
So letter
disclosed.
dated
Letter dated, reference number 25th,
25/11.
11, issued by Subroto Dasgupta, General Manager, PEE, ECL Headquarters.
Letter sanctioning prosecution.
Sanctioning prosecution.
This was
Issued from headquarters, that means Saktodia, Asunsol. Now, if your lordships kindly come, page 48,
Hmm.
the letter appointing the inquiry officer as well as, my lord, the management representative. Inquiry officer is admittedly at Dhanbad, but management representative appointed at, my lord, headquarter, from the headquarter.
No, but this letter was issued from
Dhanbad, but the persons to whom it is addressed, and, my lord, the person who will act as management representative, he is from West Bengal. Rigon Kumar Sethi, Senior Manager, Excavation Vigilance Department, ECL Headquarters, such and such, hereby appointed as management representative to present the case.
So addressee is in West Bengal and
Address West Bengal as well as copy 2, because entire thing is, my lord, originated from headquarters, and entire thing is being monitored from the headquarters. That's why, if your lordships kindly see, appointing the inquiry officer, they, to whom they have served the copies at bottom. Page 48.
yes,
Kindly see, my lord, copy 2 of that letter, my lord, page 48.
yes, I've seen.
General Manager PNIR, ECL Headquarters for information.
Hmm.
General Manager Vigilance ECL for information. And thereafter others are, my lord, at Jharkhand. 1 and 2 is from West Bengal. Because as per their direction, this charge sheet was issued. Now, page 49.
Hmm.
Kindly see the venue of the inquiry as at Bardhaman, Paschim Bardhaman. Though the charge sheet was issued from Dhanbad, inquiry, the management representative is from West Bengal. The issuance of the charge sheet, my lord, initiated from the headquarters, and, my lord, they, my lord, fix the venue at, my lord, headquarters, because headquarters is being monitoring the entire thing. Kindly see, my lord, page 49.
So summarize. Sanction from West Bengal,
My lord,
sanction from Saktoria.
Saktodia,
Then
management representative from Saktodia,
West Bengal, then
inquiry, venue of the inquiry at, my lord, at Sitalpur, Paschim Bardhaman, at, within the vicinity of Saktodia,
venue of inquiry, West Bengal,
West Bengal.
then
Now, my lord, the page 52, you also, my lord, adjoining, my lord, the inquiry also, my lord, indicating the further venue at West Bengal.
the venue is West Bengal.
Now, my lord, first day of inquiry was held at West Bengal, which I am, my lord, wanted to stay. Page 53, if your lords please kindly come. This is the most vital order sheet. Before moving the writ application, my lord, they conducted this inquiry, thereafter your lordship stayed. Kindly see the venue at top, page 53, Vigilance Department, Barachok House, ECL, that is at, my lord, within the vicinity of Saktodia, West Bengal, very much within my lord, the subdivision of Asansol. Now, my lord, the at last page of that, last paragraph of that page, 53, after considering both sides, the inquiry officer has decided to reschedule the second date of preliminary inquiry held at Vigilance Department, Borachok House at ACL.
Admittedly, venue is West Bengal.
West Bengal, and they have, my lord, came, inquiry officer, management representative sat at West Bengal. And my lord started the inquiry, which I wanted to stay, my lord. Kindly see their signature, Prasanto Kumar, inquiry
So
officer.
if entire thing, the subject matter of the inquiry,
My lord,
alleged inquiry,
my lord,
is Mugma.
Mugma,
It's an all India company,
yes,
ECL.
my lord,
It can decide to hold the inquiry proceeding in Chennai.
my lord.
So Chennai will have a jurisdiction.
But usually they, my lord, conducts the inquiry at headquarters.
Forget
I
about
ne-
headquarter. It may be conducted at Chennai also.
My lord, I have only two grounds, 226, 1 and 2,
Yes.
and 20 within bracket C of the CPC. I will come to your lordships, and the judgment, that matter has already been settled. My landed friend, I don't know why not showing the division bench judgment. In a Mugma area's case, ECL went up Supreme Court, and my lord, I don't know.
Show me.
I will. First, my lord, let me place the facts. Now, can you see the cause title? Headquarter at Asansol, that is Factoria.
Not denied.
No
not
denied. Now,
Denies Factoria.
now, if your lordships kindly come the single bench judgment as my landed friend has referred yesterday. I will start from there. Now, before that, may I read, my lord, 226 and 20 of the CPC, my lord. Your lordship has the copy.
Sir, the law, let us cut short the matter on the issue. The law is now well settled. Integral part of cause of action. Material cause of action, not the entire bundle. Bundle may be this much.
Including the seats of the respondents.
Whatever, that is also a cause of action.
Well.
So bundle may be this much. Right. Material must be this much. The rest may be facts, but may not be really may not affect you. What really affects you? That's the material cause of action. The inquiry proceeding, the result of the inquiry proceeding, and the place of occurrence of allegation.
Here, my lord, my prayer,
These are the material.
my prayer limited to your lordship, before your lordships, for staying of the disciplinary proceedings arising out of the, my lord, criminal case, which is being conducted at, my lord, Asansol. Sanction was made from Asansol. So, my lord,
Sanction was made for Asansol.
so, my lord, it is the cause of action.
No.
It is the cause of action. Here, my lord,
Suppose sanction is made. The ECL thought it fit not to proceed any further. Can happen. Can happen. What will be your cause of action? Can there be any cause of action?
no, here, my lord,
Think,
they,
if sanction is made, Mr. Ghosh,
my lord,
sanction made.
so that is also part of the cause of action.
No. Sanction made. Maybe part of cause of action,
Yes.
but not material.
Here, my lord, Supreme Court has says any fraction of cause of action.
No, any fraction of cause of action which is a part culminating into, that's the language used by Supreme Court,
I will satisfy.
culminating into the result.
I will satisfy your lordship the Supreme Court or my lord judgment against ECL.
No, you show me.
I will.
Show me.
Now, my lord, if your lordship kindly come page 226, my lord, first. Your lordship has the, my lord, I have all.
এ তো সেট আউট করা আছে জাজমেন্ট
ঠিক আছে।
কুসুমেই সেট আউট করা আছে ভেরি ওয়েল
But 226 1 and 2 are independent.
yes of course
1 and 2
one
are
gives the right, two gives the cause of action,
both are, my lord,
territorial
yes,
boundary.
yes. Notwithstanding anything, Article 2032, every High Court shall have powers throughout the territories in relation to which it exercise jurisdiction to issue any person or authority, including in appropriate cases, any government within whose territories directions, orders or writ, including writ in the
Let's
letter of so.
read two. Let's read two. Because
Now,
nobody doubts that you have a right to maintain
yes,
226.
the power conferred by Article 1 to issue directions, order, writ to government authority or any persons may also be exercised by the High Court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within the territories. Here, my lord, the seats are here. Here, in a case, suppose
Cause of action. Cause of action.
cause of action inclusive of the seats, because seats, unless my lord headquarter does not monitor or unless headquarter is segregated, if the headquarter is segregated, they cannot, because my salary, my continuation of service and everything monitor, control from the headquarter. When the headquarter is here, so my lord, 2 is also not applicable. Even if I, my lord, say
Sir, let us read. Exercising jurisdiction in relation to territories.
yes, here headquarter is
within which cause of action wholly or in part arises.
yes, part arises.
For exercise of such power. Now read. Notwithstanding, which means in spite of.
Yes.
Notwithstanding that seat of such government or authority or residence of such person is not within those territories.
Yes.
So it is hardly matters if the cause of action arose in Jharkhand, whether ECL headquarter is at Sectoria or not, does not matter. Does not matter.
No, here, my lord.
Yes. That's the reading.
Here, officer in both places. GM office at Jharkhand, headquarter is at here. So, not
your cause of action, material cause of action, whether arose within West Bengal or not. That I have to answer.
Very well. Now, my lord, can I come, my lord, the section 20 of the CPC?
Same, identical, not required.
No, no, there is a difference in section 20. Can I come?
Yes, section
20 of the CPC, my lord.
Yes.
Subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction the defendant or each of the defendants, where there are more than one at the time of the commencement of the suit.
This gets diluted the moment 220, you read 226.2. 226.2 says, give primacy to the cause of action, irrespective where it resides or not.
Cause of action when there is no office. Cause of action when there is no office. Here there is office. There are difference between the office.
But the cause of action
business seats and business. I am coming. I will satisfy to lordship on judgment.
Show me the judgment. Show me the judgments.
May I read, my lord, quickly, my lord? The defendants or each of the defendants where there are more than one at the time of the commencement of the suit actually and voluntarily resides or carries on a business or personally working for gain.
Read this side by side with 226.2.
No, 2 is, my lord, 20C. 20C is the 226.2.
That's right.
Yes.
So B does not apply. It gets diluted the moment you will read 226.2.
Now, my lord, kindly come B. Then, my lord, C, my lord, I am coming, my lord. Any of the defendants where there are more than one at the time of commencement of the suit actually and voluntarily resides or carries on business or personally working for gain, provided that in such cases either the leave of the court is given or the defendants who do not reside or carry on the business or personally work for gain as the aforesaid acquisitions in these institutions, or in three circumstances the suit is maintainable: A, B, and C. The cause of action wholly or in part arises.
Sir, the moment 226(2) is there, we will have to go by that.
See here 1 and 2, because
One is the cause of action.
226 1
One is the right. One is the right. One has got nothing to do with
So,
the
my lord,
jurisdiction,
here,
territorial
Then, my
jurisdiction.
lord, I'm coming to the judgment, my lord. Well, kindly come, judgment my learned friend has cited yesterday. Single bench judgment. Division bench is also supporting to us. Before that, my lord, may I so to your lordship the Kollan Bandyopadhyay judgment as has been referred by the single bench.
Yes.
My lord, দিন না judgment.
দেখি দাও।
ওই তো তুমি তো কালকে বললে পরের মধ্যে 2008 volume 3 SCC page 456 paragraph 5 and 6 2008 volume 3 SCC page 456
Para
5 and 6 only, my lord. Mr. Onif Sajde, learned counsel appearing on behalf of the appellant means from the Eastern Coalfield Limited, submitted that it is not a case where the sanction of the corporate office or head office was required to be taken. The entire cause of action having arisen with the territorial jurisdiction of Jharkhand High Court, the Calcutta High Court could not have exercised any jurisdiction in the matter. The Honorable Supreme Court relegated the matter to the Jharkhand High Court only on the basis that the entire cause of action arose when
then
Then, my lord,
Court
the
could not
jurisdiction
have
to
exercised any jurisdiction in the
to
matter. The
Yes.
jurisdiction issue of
It in nature manner is conferred on the High Court.
is conferred
Conferred,
upon High Court under Article 226(2).
my lord.
However,
provide that if cause of
if
action
cause of
had
action had arisen in more than one
On
court,
any of the courts where the
any
part
of the courts or part of cause of action arises,
will
will
have the jurisdiction to enter the petition.
But you should, then I have to decide that whether this is a material cause of action.
Yes.
These two documents, 48 and 49, or
Yes.
46 and 48,
Everything
whatever.
will be answered, my lord. May I clear, my lord? Now, my lord, kindly come, my lord. The single bench judgment, as my learned friend referred yesterday. Page number 4.
কোথায়?
Single bench judgment, my learned friend has referred yesterday.
Single bench কোথায়? না, এটা তো পিটিশনার, এটা এখানে রাখুন, ওইটা দেখি। রেসপন্ডেন্টের ফাইল। এটা পিটিশনার লেখা রয়েছে উপরে। দেখি আমায় দিন না। তো ওখানে ওটা ঢুকলো কি করে? এই তো পিটিশনার, এইগুলো সব পিটিশনার। তাহলে ও রেসপন্ডেন্টের ফাইলটা দেখি। উপরে লেখা রয়েছে তো, তারপরেও গন্ডগোল হচ্ছে না। সিঙ্গল বেঞ্চ reported in
my lord 2013 SCC online Calcutta 2013 SCC online Calcutta 10678 of Justice my lord Justice Sombudhu Chakraborty Aziz Lodge Bench was single bench judgment, my lord.
19 Calcutta, Sima Sarkar.
No, my lord, 2013, my lord. Yesterday, possibly, my learned friend hand over.
No. Wait. So দেখি আপনারা এদিক ওদিক করে দিয়েছেন আমার মনে হচ্ছে। এর জাজমেন্ট ওখানে, ওর জাজমেন্ট ওখানে, উপরে লেখা রয়েছে তো রেসপন্ডেন্ট আর পিটিশনার, এই তো লেখা রয়েছে উপরে পিটিশনার। দেখি
This one, my lord.
99(3) SCC, who cited? You cited 99(3)?
99, my lord, I have cited 2004-9 SCC.
99(3) SCC? না, পার্থ ঘোষ। এই তো পিটিশনার, তো এটা তো পিটিশনার। হ্যাঁ, তো ঠিকই তো আছে। কি এটা?
Single bench judgment, my lord, I have, my lord, folded, my lord.
হ্যাঁ,
I have,
হ্যাঁ।
well, folded.
ঠিক আছে।
My internal page 4 of that judgment. My learned friend yesterday, my lord, submitted this judgment with regard to, my lord, the matter of Bharat Coking Coal Limited. Their head office is at, my lord, Dhanbad. My lord, may I read, my lord?
Yes.
It appears that the ratio decided in the case of Eastern Coalfield Limited versus
Page.
internal page 4 of the judgment. Single bench judgment.
It appears.
It appears, my lord, may I read, my lord? It appears that the ratio decided in the case of Eastern Coalfield Limited versus Kollan Bandyopadhyay Banerjee squarely applies to the facts of the present case. Here also the subject matter of challenge in the charge sheet issued by the agent of colliery which is in Mugma, Dhanbad in the state of Jharkhand. The actions were taken in the state of Jharkhand and the petitioner was dismissed from the service after an inquiry which was conducted within the state of Jharkhand. The petitioner was dismissed by the authority in the state of Jharkhand. If we consider the relief sought to be by the petitioner, it appears that he has prayed for an order directing the respondent to set aside the order of dismissal served upon him and restraining the respondent from taking any step in furtherance thereof. He has also prayed for quashing of the charge sheet and the ex parte inquiry proceedings. That one thing is clear, that all the directions he had prayed for is with regard to the events occurring within the state of Jharkhand. Merely because the appointment letter was issued from the West Bengal will not confer jurisdiction upon this court to entertain the writ petition. It has already been seen that the Supreme Court has repeatedly stressed that every fact pleaded in the petition will not constitute the part cause of action unless the same has any nexus with the lease or relief sought for. The petitioner made as a point that the office of the appellate authority has its area within the province of West Bengal, but this is inconsequential inasmuch as the petitioner is not challenging the order of the appellate authority and the appellate authority has only area office within the state. The petitioner has, this is very vital part, this part, my lord. The petitioner has referred to the judgment and order dated such and such passed in FMA, that is, my lord, in division bench Sotrughn Majhi versus Coal India Limited. There, the division bench of this court had held that the registered office of Eastern Coalfield Limited is in district of Bardhaman. This court can assume jurisdiction under Article 226 of the Constitution of India in respect of the matter concerning the Eastern Coalfield Limited. Here, kindly, my lord, pause a moment. The matter relates to Dhanbad, that is, my lord, the Bharat Coking Coal Limited, this judgment. They challenge the action of the Dhanbad in Kolkata High Court. Their head office at there. Now, my lord, the learned advocate appearing on behalf of the appellant, the writ petitioner, submitted the division bench judgment, 3 division bench judgment concerning the Eastern Coalfield Limited, though the matter relates to Mugma area.
Though the matter
relates to Mugma area, that is a Jharkhand matter, same area. Here, the single bench hold, my lord, I will satisfy to your lordship and so to your lordship the division bench judgment, mother judgment. Eastern Coalfield Limited is district of Bardhaman. May I read again, my lord? The petitioner has referred to the judgment and order dated such and such passed in FMA in the division bench. There, the division bench of this court had held as the register office of Eastern Coalfield Limited is in the district of Bardhaman. This court can assume jurisdiction under Article 226 of the Constitution of India in respect of the matter concerning the Eastern Coalfield Limited. The petitioner also relied on the judgment and order dated such and such passed in APO number such and such Jafar Khan versus Coal India Limited, and the judgment and order dated such and such Sufal Bhuiya, all are division bench. They are also a division bench of this court had held that this High Court has territorial jurisdiction to entertain the writ petition as the head office of the register office of the Eastern Coalfield Limited was within the territorial jurisdiction of this court. The difficulty applying the principle to the facts of the present case is that the Eastern Coalfield Limited is not party to these proceedings because that matter was related to Bharat Coking Coal Limited. So obviously Eastern Coalfield Limited will not be party. Proceedings, Coal India is holding company. Its registered office at office of the chairman of the Bharat Coking Coal Limited is in Dhanbad. It has been submitted that respondents that the holding company of Coal India only takes the policy decision of everything is done by the Bharat Coking Coal Limited. Moreover, as mentioned earlier, the Bharat Coking Coal Limited is also established. So, my lord, here they have made in this judgment Bharat Coking Coal Limited and Coal India. Now they wanted to, my lord, invoke the jurisdiction of this honorable court that the Coal India's office at Kolkata. And they cited the judgment of Eastern Coalfield Limited, whose office at West Bengal. Now the division bench has said that the head office is here, it is maintainable in a case of Mugma areas matters. Now, my lord, the single bench hold, which my learned friend has, my lord, I'm grateful, my lord, to him, my lord, that he supported my case, that the ECL is not party in this matter because this matter relates to Dhanbad, the Bharat Coking Coal Limited. So had it been the case that the ECL would have been the party, the writ petition is maintainable. Now I'll show to you lordship the division bench judgment.
No, but in your writ petition, in this writ petition,
ECL it is a matter of ECL.
that's right.
Yes.
So admittedly, you have your registered office within.
Yes. So this is
No denial.
so this is the judgment supporting me.
No, no.
I am coming to your lordship with the division bench judgment, my lord, against the ECL.
You're taking support from Kusumingot.
Kusumingot,
You're taking support.
Kolan Bandabadhai, followed by division bench.
You're taking support from Kusumingot. That Kusum you are relying upon. Read 9 and 10. Dekhi?
Kusumingot.
Yes.
Which paragraph, my lord?
9 and 10.
9 and 10.
Read Kusum 9 and 10.
My lord, matter of Kusumingot relates to the part cause of action. My case is not only based on the part cause of action. My case is based on the mother 226 as well as if it is not accepted, then 226 too. Both are covered in my case because head office is here. Controlling authority is here.
Your head office situation, mere situation of head office will not do.
Division, I will satisfy 3 division bench judgment.
All right, because read 226.2.
Yes. Now kindly come.
226.2 says notwithstanding.
Not suppose if I, my lord, the order of authority, the order of dismissal or anything is served at my lord Bihar. In a case of Jharkhand, matter relates to Jharkhand, head office at my lord the West Bengal, and if it is served at my lord Bihar, then only not the clause, not non-obstantive clause will come in play.
The material cause of action, if arose Jharkhand, even if you have a headquarter in West Bengal, Jharkhand will have the jurisdiction.
Then kindly come the paragraph 9 and 10 as your lordship says. Although in view of the section 141 of the Code of Civil Procedure, the provisions thereof would not apply to the writ proceeding. The phraseology used in section 20C of the CPC and clause 2 of the 226 being perimetria, the decision of this course rendered on interpretation of section 20 of the C CPC shall apply to the writ proceedings also.
Then read carefully.
Yes. Before proceedings to discuss the matter further, it may be pointed out that the entire bundle of facts pleaded need not to constitute a cause of action, as it necessary to prove before
as what is
necessary to prove before the petitioner can obtain a degree is the material fact. Right. The expression material fact is also known as integral facts. I am not denying.
Yes.
I am not denying.
So wait. Here, what is your material asking? relief that you quash the criminal stay the disciplinary proceeding.
Initiated at the instance of the issue of the sanction of the headquarters.
No. Kindly see your prayer. You have asked for stay of the show cause.
Yes, stay of the disciplinary proceedings, which was based on the issuance of the sanction letter by the headquarters.
No, that cannot be a material cause of action.
Then, my lord,
Sanction cannot be a material cause of action.
then, my lord,
Your cause of action is only the disciplinary proceeding. And the disciplinary proceeding you are asking for stay. Now read in the light
now
of
the
that.
disciplinary proceedings is being conducted at Asansol. Disciplinary proceedings is being conducted at
That's
Asansol.
the seat. That's the seat.
Seat is also the cause of part of
Yes,
cause of action.
no.
Now, keeping
Before
in view,
proceeding to discuss the matter further,
yes,
it may be pointed out that the entire bundle of facts pleaded need not constitute a cause of action, as what is necessary to be proved before the petitioner can obtain a degree in the material facts, which means the ongoing disciplinary proceeding started and culminated due to the criminal complaint. Those are your material
well,
facts.
I will satisfy to lordship.
Now read the next expression.
Keeping in view of the expression used to it in clause
Material
26,
Huh.
indisputably, even if small fraction of cause of action accrues within the jurisdiction of the court will have the jurisdiction in the
What
matter.
is your cause of action? Your cause of action is material cause of action is not the sanction.
Then, my lord, based on this judgment, my lord, I will satisfy to your lordships in the division bench judgment. That has been interpreted and that has been followed, not interpreted. The Kusumin God and Kollan Bandabadhai, everything has been, my lord, discussed in this division bench judgment. 2009, volume 2, 2009, volume 2, CHN Cal 1. CHN 1. There is no, my lord, a paragraph in this judgment.
Paragraph?
There is no paragraph. I will show to your lordships from the page itself. Page 3. This is also the concerning the Mugmairias matter, Dhanbad matter, my lord. There is the paragraph 3, page 3, if your lordships kindly come. 1, 2, 3, 4 paragraph from top. Your lordship got it, my lord?
Yes.
4 paragraph from top of page 3, my lord. 1, 2, 3, 4. There is no dispute. You got it, my lord, that opening part.
Yes.
There is no dispute that the head office and registered office of the respondent coal company are within the territorial jurisdiction of this honorable court. The notice of superannuation was, however, issued by the respondent number 3 from the colliery office, which is admittedly outside the territorial jurisdiction of this court. The fact relates to, my lord, the Mugma area. The notice of superannuation was issued to the petitioner, and, my lord, from the colliery office, that is at Jharkhand. Now head office is at here. Now, if your lordships kindly come, the last two paragraphs of that very page, the jurisdiction of the High Court in exercise of my lord. The jurisdiction of High Court in exercise of its power under Article 226 of the Constitution of India is determined by the two parameters laid down in Article 226(1) and 226(2). 226(1) clearly provided that the High Court will have the power to issue directions, order or writ to any authority throughout the territories in relation to which it exercises jurisdiction. Article 226(1) is quoted. Thereafter, my lord, I am not reading the quoting part. Now, there is, however, no dispute. If you lordships kindly come after quoting part, the observation of the court. Next page. You lordships got it, my lord? There is, however, no dispute that the authority mentioned in Article 226(1) should be an authority within the meaning of Article 12 of the Constitution of India. Therefore, in view of the clear provisions of Article 226(1), if the seat of the offending authority is within the jurisdiction of a High Court, then the High Court will have the jurisdiction to entertain a writ applications against the authority, irrespective of where the offending act has been committed. Here, my lord, similar facts and circumstances, my lord. Here, the matter notice was issued from the Mugma area, that is at Jharkhand. Now, next page, page 5. Second paragraph from top.
Here Kusum was not considered.
Kusum was considered, my lord.
Considered?
Yes, Kusum and Kollan Bandobad, everything was considered.
Yes.
In the event, my lord, the second paragraph of top.
In the event.
In the event, the offending authority is within the jurisdiction of a particular High Court, then by virtue of Article 226(1) of the Constitution of India, the High Court will have the jurisdiction irrespective of the fact as to where the cause of action has arisen. The Honorable Supreme Court in a case of Omprokas, such and such, I am not, my lord, reading the entire discussion part. Now, next page, my lord. All judgment, Kusumin Court, Adani expert, every entire judgment holding the field has been, my lord, considered. Page 6, if your kindly come. Almost, second paragraph, almost all the judgments relied upon by the learned single judge and subsequently referred before us by the learned council of the respondents on the jurisdiction of the High Court under Article 226 of the Constitution of India are cases where the jurisdiction was invoked under Article 226 of the Constitution of India. Now, there is a discussion.
No. Kindly see now Kusum. What does it say?
Kusum. Yes. In a case of Kusumin Got, reported such and such is also a case where the jurisdiction was invoked under Article 226(2) of the Constitution of India, and question discussed was whether the cause of action or any other part has arisen within the territorial jurisdiction.
Any cause of action or any part, not
Yes.
the seat of the corporation.
Yes.
Here the cause of action or any part.
Kusum was
also on that.
Yes, Kusum was not with related to the seat. Here also seat as cause of action, both.
No.
In the same area.
Where the seat and cause of action both, then the cause of action shall prevail, not the seat. That's 226(2).
226(1).
226(2).
226(1). If there is a, if I covered under Article 226(1), there is no necessity to go for 226(1).
Had a necessity.
Because
226(2) defines the territorial jurisdiction.
Because both are, my lord, holding the field independently.
No, yes. If you cannot come within 226(1), you cannot come under 226 at all. Right? Now you come under 226(1). No denial. The moment you come under 226(1), then the question will arise, where the territory. Then the answer is 226(2).
I'm coming to that answer because this matter.
226(1) is your substantive right. If your right is vitiated or infringed under 226(1), you can maintain a 226, but not anywhere in the India. Where? That is the answer under 226(2), where it says where cause of action has arisen.
My lord,
Notwithstanding the fact its headquarter or not. Now, what is cause of action? Those are defined under these Supreme Court
this
judgments.
matter is also, my lord, relates to the Dhanbad against Eastern Coalfield Limited. This is a division bench order. So is it not binding upon them?
Of course, binding, but more binding is Kusumin Court. It's of Supreme
Kusumin Court have to be considered.
Considered on not that respect.
Because Kusumin Court, the issue of Kusumin Court was only in respect of 226(2).
I will say that Kusum is, since Kusum is there, I am bound by it.
Then, my lord, kindly come the another, my lord, the second paragraph from the bottom of that page.
Yes.
In interpreting the case of Om Prakash Srivastava, Union of India, the Supreme Court held that the High Court will have the jurisdiction if cause of action, whole or part, arises within the territory, even though the seat of the government or authority against whom the direction order is issued is not within the territory. In other words, the Supreme Court reiterated that in Article 226(1) of the Constitution of India is independent and Article 226(2) of the Constitution, and if the High Court has the jurisdiction to entertain the application 226(2) of the Constitution, it is immaterial whether Article 226(1) of the Constitution is satisfied or not.
Kindly let us read 226(1). Come to this judgment, it is quoted.
Here,
Quoted. Come to second page or third page, like that.
4th page,
Second page, or fourth page, whatever.
4th page.
226(1).
Notwithstanding anything in Article 32,
Slowly.
every High Court shall have power throughout the territories in
Throughout
relation
the
territories.
So, if you omit the word territory for the time being, so what it happens? Throughout every High Court shall have power. So 226(1) first defines whether the High Court has power to entertain your case. Correct. You have to satisfy the test of 226(1) to maintain a 226. Right? Now read. Notwithstanding anything, 32. 32 is different. Every High Court shall have power to issue any person or authority, including the inappropriate case any government within whose territories, directions, orders, writs, including writs in the nature of blah 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 blah. So first you have to satisfy under this provision two things: that your right has been infringed. What are the rights for which you can apply under 226? That is why notwithstanding 32. Because 226 is 32 plus any other right. 32 is a restricted provision.
Fundamental right.
And 226 is 32 plus. So you have to first show that you have a right within 226(1) which is infringed. If you can show that, then your 226 will be maintainable. Right? Now come to 226(2). It is quoted.
Power conferred by clause 1
Slowly. Power conferred by clause 1.
to issue directions, order or writs to any government authority or persons may also be exercised by any High Court exercising jurisdiction in relation to the territories within which the cause of action wholly or part arises for the exercise of such power. Notwithstanding,
again.
yes,
Notwithstanding.
notwithstanding a fact, notwithstanding that the seat of such government authority or the residence of such person is not within those territories.
So now, the moment it is not notwithstanding clause, it's two different.
My lord, may I
First,
may I explain, my lord? Here, my lord, initially, my lord, there was only 226. Then thereafter, my lord, the authorities have, my lord, the jurists have thought that there may be another jurisdiction be created for assuming the jurisdiction by the concerned high courts. Like Noble Kishore judgment my learned friend has cited, I also rely that judgment. What happened in Noble Kishore? The person was posted at Jammu. He was terminated after court martial from Jammu. The copy was served to him through post at Bihar. Now thereafter, the person Noble Kishore preferred appeal by post from Bihar to Jammu. The order of appellate authority also passed from Jammu and communicated to him at Bihar. The Patna High Court said, no, we don't have any jurisdiction. Finally, Supreme Court has said, invoking the power under Article 226(2), that irrespective of the seat, that is the non-obstantive clause in respect of 226(2).
I am saying the same thing, irrespective of the seat.
Irrespective of seat, in respect.
Where the cause of action arose.
No, cause of action arose at Jammu, then even then Noble Kishore has.
The moment he received the notice at Bihar, to him that the
Lord,
material part of cause of action.
Is it integral part to decide the issue? I'm asking question myself.
Yes. Yes. Because otherwise, how Noel could know that he has been suspended or sacked or whatever?
But my
The
case,
moment he received the notice of whatever, sacking or dismissal, his right is infringed. His right is infringed.
now here,
It reminds me, lighter note, it reminds me of an extremely respected senior member of the bar. His comment is, it reminds me of his comments as to what is cause of action. I don't find anybody is here
my lord, may
who
I,
have heard it.
No, may we know the name, my lord? Well, sometime it's, my lord.
If
Yes, my lord. My lord.
we could get the opportunity, I
My
will
lord.
tell you, and I will tell you the incident.
actually-
we are told. We are told.
Some histories are always, my lord, precise to us, and my lord always remembered, my lord.
And I will tell you.
My lord.
I will tell you, both of you, if I get the opportunity.
My lord. And my lord, my case is independent 1 and 2. Now may I place the division bench judgment, my lord? Because before vacation, your lord, she was giving us, my lord, patience hearing. Page 6, my lord.
No, but ultimately it will go after vacation because I will invite written notes from you.
Then, my lord, fix after vacation. I will complete, my lord, after vacation, because I have don't record that I have completed, my lord. I will, my lord.
No.
Very
You will proceed.
My lord.
You will continue.
Very well, my lord.
Or you can do one thing. You can conclude.
I have, my lord.
Both of you come up with a written notes on the next week. Or after I come back from circuit, you file your.
As well as you desire, my lord. I have not.
I know. You conclude and then file your written notes.
Today.
No. Today you conclude.
My lord.
And then you file your written, both of you file your written notes.
Very well. Now, if you lordship kindly come, page 6.
Yes.
Second paragraph from bottom.
From this
judgment of division bench, my lord.
No, this one.
Division bench judgment at.
You are placing.
Yes.
Page?
Page 6.
Page 6 nahi kichu. Mark kora nahi.
Second paragraph from bottom, my lord.
Starts with?
In interesting case.
No.
Jafar Khan, my lord, in the matter of Jafar Khan versus Coal India.
Page 6. It's going to pagination nahi.
At top, your lordship will find. At left hand side at top, at corner.
Yes, page 6.
My lord.
In the case of Union of India Adani, then Kusum Ingot.
Then, my lord, at second.
It is in an interesting case.
Yes. In an interesting case of Om Prakash Srivastava versus Union of India reported 2006 such and such, the Supreme Court held that the High Court will have jurisdiction if cause of action wholly or in part arises within the territory, even though the seat of government or authority against whom the direction, order or order is issued is not within the territory.
Precisely.
Yes. In other words, the Supreme Court reiterated that the Article 226(1) of the Constitution of India is independent of Article 226(2) of the Constitution. If the High Court has jurisdiction to entertain a writ application under Article 226(2) of the Constitution of India, it is immaterial as to whether Article 226(1) of the Constitution of India is satisfied or not. My submission is this, my lord. If I can satisfy 1, 2 is not necessary. If I can satisfy 2, 1 is not necessary.
It is not so.
Yes.
if a high court has jurisdiction to entertain a writ petition under Article 226(2) of the Constitution of India, it is immaterial as to whether 226(1) of the Constitution is satisfied or not.
Yes.
But
It is
226.
vice versa. It is vice versa.
No.
Now,
226(1) is the substantive provision, and 226(2) determines the jurisdiction, territorial jurisdiction.
now, my lord, kindly come. May I read, my lord? In this background, the judgment of the Supreme Court in Eastern Coalfield Limited versus Kollan Bandyopadhyay, well, this is very vital judgment governing the field. As my lord, the ECL has preferred appeal up to Supreme Court, and this is the last judgment of the Supreme Court relating to the territorial jurisdiction concerning the Mugma area, that is of Dhanbad, of Eastern Coalfield Limited. It is in this background the judgment of the Supreme Court in Eastern Coalfield Limited versus Kollan Bandyopadhyay reported in such and such is to be looked into. In the aforesaid case, the services of an employee of Eastern Coal Limited was terminated at Mugma, district Dhanbad in Jharkhand. The issue of jurisdiction was considered only on the basis of cause of action had arisen within the jurisdiction of Jharkhand High Court. This will be apparent from the submission of the learned counsel appearing for the Eastern Coalfield Limited as recorded in paragraph 5 of the aforesaid judgment. The Supreme Court was therefore examining as to whether the entire cause of action had arisen within the jurisdiction of Jharkhand High Court. The Supreme Court, after referring to some of its earlier decisions, proceeded on the basis of the findings of the Division Bench of Calcutta High Court, which was under appeal, that the entire cause of action arose at Mugma area within the state of Jharkhand. The question as to whether the status of the head office of the Eastern Coalfield Limited in West Bengal was not the issue for consideration before the Honorable Supreme Court. My lord, may I pause a moment here, my lord? May I read again, my lord, this part? The Supreme Court, after referring to some of its earlier decisions, proceeded on the basis of the findings of the Division Bench of Calcutta High Court, which was under appeal, that the entire cause of action arose in Mugma area within the state of Jharkhand. The question as to whether the seats of the head office of the Eastern Coalfield Limited in West Bengal was not in the issue for consideration before the Honorable Supreme Court. The dicta in the concluding portion of the said judgment makes it clear that the Supreme Court was not deciding or expressing any conclusive view on the question of jurisdiction on the basis of the seats of the head office of the Eastern Coalfield Limited in West Bengal,
Right.
which, according to the court, by itself would not confer any jurisdiction upon the Calcutta High Court, particularly when the head office had nothing to do with the order of punishment passed against the respondent. The aforesaid conclusion undisputedly does not touch the issue. It does not say that the company did not have its registered office within West Bengal, and hence Article 226(1) will not apply. It only says that the case of the jurisdiction cannot be invoked under Article 226. This is my case.
Yes. I am also with you.
Now,
That you are attracted by 226(1). Your right is infringed or threatened to have been infringed. So you can maintain 226
Yes.
under 226(1). But where? This where is the answer to be looked into from 226(2). Where?
here, my lord, the same thing.
No, not same thing.
Same
Here,
thing.
the Supreme Court did not make any comment on the situs of the
Yes,
head
that's why
office.
Division Bench has, my lord, that part has covered. Division Bench has covered that part.
226(2), the
Well,
moment
here also Mugma area, Dhanbad, termination from there. He filed writ application here. In Division Bench, my lord, Kusum got, as well as, my lord, the
Kusum is not that. I will follow Kusum. Kusum is not that.
but Division Bench has taken into consideration against the Eastern Coalfield Limited. Is
But
it binding upon them?
yes, so I will follow Kusum. I will refer to this and I will follow Kusum. Kusum is the law laid down. And that's
Kusum,
140
Kusum is also, my lord.
and that's 141. Article 141.
No, yeah, Division Bench judgment is also binding.
Absolutely.
Absolutely. binding.
Absolutely. It's binding on me.
Unless
But the moment Kusum is there,
unless it is no, Kusum has been, my lord, taken into consideration by the Division Bench.
yes,
Here parties are same.
yes.
Here Eastern
But the
Coalfield Limited.
law let down in Kusum will be a superior binding effect on me. It's of 141 under.
My lord, then,
Supreme
my lord, there is a judgment, my lord, your lordship knows. If your lordship, my lord, do not accept the division bench judgment, so, my lord, I need not to, my lord, say your lordship knows, my lord. What,
No.
my lord?
I will refer to this, but I will follow. Where is the bar in following Kusum? Kusum is of Supreme Court.
Kusum is Supreme Court,
Hmm.
but that part which is not covered in Kusum as well as Kollan Bandyopadhyay, because Kollan Bandyopadhyay judgment is
Even
Supreme
if
Court
it is-
judgment.
If it is not covered, if on the issue pat on the point, Supreme Court decision is there, that's the law of the land.
Then, my lord, let me, my lord, read the entire. The particularization that the head office had nothing to do would have been wholly unnecessary if it was declaring the law that the seats of the head office cannot be relevant matter for consideration of the jurisdiction of the High Court under Article 226 of the Constitution of India. We do not think that it would be proper for us to adopt the view that the Supreme Court had intended to take away the basis of clause number.
Yeah.
Yes.
Kindly see. Is this, I do not know whether.
Yes, I am, my lord, covered. Well, I have checked up this judgment before, my lord, I place. We do not think that it would be proper for us to adopt the view that the Supreme Court had intended to take away the basis of clause number 1 of Article 226. We also cannot overlook that the learned judge who delivered the judgment, this is a very vital part, because the SB Sinha, my lord Justice Sinha, was in both the matters, in Kusumingot as well as the my lord, the Kollan Bandyopadhyay matter. View the Supreme Court had intended to take away the such and such. We also cannot overlook that the learned judge who delivered the judgment of Eastern Coalfield Limited Supra had, while delivering the judgment of 3 judges bench in Kusumingot, referred the case of Lieutenant Colonel Khajar Singh, such and such, and quoted the relevant passage from the judgment in paragraph 28, which is reproduced here in below. Lieutenant Colonel Khajar Singh, Union of India, whereupon the learned counsel appearing on behalf of the appellant placed strong reliance was rendered at the point of time when the clause number 2 of the Article 226 had not been inserted. In that case, the court held that the jurisdiction of the High Court under Article 226 of the Constitution of India properly constitute depends not on the residence or location of the persons affected by the order, but the persons or authority passing the order and the place where the order has effect. In the latter sense, namely the office of the authority which is implement the order would attract the territorial jurisdiction of the courts considered having regard to the section 20 within bracket C of the CPC. The concept of cause of action cannot, in our opinion, be introduced in Article 226, for by doing so, we shall be doing away with the express provisions of the content therein, which requires that the persons or authority to whom the...
Sir, this is a judgment of 61.
Yes.
And when this 226(2) was incorporated?
No, that has been referred. Subsequently.
Then?
Subsequently.
Then? So 61 judgment. And 226(2) was introduced when?
63 possibly, my lord. 63. No,
Subsequent.
Subsequently.
Subsequent incorporation. No. Don't place this.
Now, no, that has been quoted here.
No. Don't place this. Because...
Now, my lord, the last paragraph of page 9. In the present case, Calcutta High Court has territorial jurisdiction to entertain the present writ petition in view of the clear provisions of Article 226(1) of the Constitution of India.
In SLP preferred from this order?
Dismissed.
From this.
In the present case, the Calcutta High Court has territorial jurisdiction to entertain the present writ petition in view of the clear provisions of Article 226(2)(1) of the Constitution of India as the seat of offending authority, namely the head office and registered office of respondent companies within the territorial jurisdiction of this Honorable Court. However, we also cannot ignore that the substantial part of the cause of action has also arisen within the territorial jurisdiction of this Honorable Court in view of the fact that the appellant herein submitted a representation to the respondent authority for taking necessary steps to correct his date of birth and before disallowing his representation, so that is not material. Therefore, in any event, the High Court has jurisdiction to entertain the writ petition such and such, such and such, and such. So in the purpose of circumstance, we have also no hesitation to hold that this court is competent to exercise jurisdiction both under 1 and 2 of the Constitution of India for the purpose of entertaining the writ petition filed by the appellant herein. For the aforesaid reasons, the decision of the single judge cannot sustain and same is accordingly set aside and matter was remanded for fresh consideration. Now, my lord, may I show to your lordship the another division main judgment.
61 Supreme Court by that time cannot be a good law when 226
61 has been
introduced.
only quoted from the Supreme Court's order. In Supreme Court, in other.
No, the division bench has quoted, division bench said, while delivering Kusum, 61 Supreme Court was not considered. But 61 Supreme Court was much prior to 226(2) was introduced.
So that is whatever the fact, but ultimately
So the
division-
moment 226(2) has been introduced, it is a law of the land. Whatever prior thereto, without.
No, I am not
226(2)
relying
is
that
bad.
part. I am only relying that 1 and
All right,
2 both
all
are.
right.
Now, my lord, another division bench judgment on the same facts against the Eastern Coalfield Limited. দিন তো
কি দাও ভেতরে?
আরেকটা judgment দিন তো।
Petitioner. And
বলছি দাঁড়াও, আমার ন্যায়কে দেখো। Paragraph 5. Paragraph 3, if your lordships kindly come. 2002 SCC online Cal 818. Paragraph 3, if your lordships kindly come.
yes, paragraph.
Paragraph 2. The present appeal is directed against the order dated such and such part by the single judge of this court, dismissing writ petition, the appellant petition on the ground that this court has no territorial jurisdiction to entertain and try the matter, as no part of cause of action has arisen within the jurisdiction of this court. After hearing the learned counsel for the parties and considering the materials on record produced before us, we are of
Where?
paragraph 2.
2, yes. Read on.
The present appeal is directed against the order dated such and such passed by the learned single judge of this court, dismissing the writ petitions of the appellant writ petitions on the ground that this court has no territorial jurisdiction to entertain and try the matter, as no part cause of action has arisen within the territorial jurisdiction of this court. After hearing the learned counsels for the parties and considering the materials on record produced before us, we are, however, of the view that the trial court has fallen into error in holding that the Calcutta High Court has no territorial jurisdiction to entertain and try the matter. In the present writ petition, the appellant writ petitioner, who admittedly was an employee of ECL and was working at relevant point of time as underground loader at Lokhimata Colliery. Lokhimata Colliery is, my lord, at Mugma, Jharkhand, has challenged this order of dismissal dated such and such passed by the general manager Mugma area, having his office at Dhanbad in the state of Jharkhand. It is not disputed that such order of dismissal was passed outside the territorial jurisdiction of this court, and at the relevant point of time when the petitioner was dismissed, he was working in Colliery, which was situated outside the territorial jurisdiction of this honorable court. That's what the fact. Now, my lord, kindly come. Paragraph 6. Admittedly, in the instant case, Eastern Coalfield Limited has its head office at 13 Naran Mukherjee Road within the jurisdiction of this court, and the said Eastern Coalfield Limited has been impleaded as point number 2 in the instant writ petition, similar to the same. This court therefore has territorial jurisdiction to entertain and try the jurisdiction even if no part cause of action has arisen within the jurisdiction of this court. This aspect of the matter was totally overlooked by the trial court. The fact that the High Court can entertain and try the writ petition even though no part cause of action may arise within the territorial jurisdiction, in the event the seats of the authority or any other respondent is within the territorial jurisdiction of such High Court, is no more res integrator, and such position of law has been settled by the number of division bench judgment of this honorable court. Now the division bench, all the division bench judgment has been quoted. Thereafter, my lord, the ratio of the decision in the aforesaid case in Khoghan-Bauri on the question of lack of territorial jurisdiction is very much applicable in the present case. In the case of Khoghan-Bauri, the writ petition, namely Khoghan-Bauri, was also posted at Colliery under Sheikh Mugmaria. So entire fact has been discussed with regard to the territorial jurisdiction of Mugmaria since the head office at here, apart from my lord the 226.
ये कবে का judgment? Kusumin Got?
Kusumin Got হচ্ছে 2004.
This is of 2002.
And Jafar Khan is my lord 2009.
Kusumin Got 2004. Yes.
Now, my lord, the paragraph 13, it is further held in the judgment that the writ petitioner in the said case prayed for a issue of writ of nature of statutory and records of the case. So it is not necessary, my lord. Paragraph 15, my lord. 16. In such view of the matter, the Eastern Coalfield Limited, as also the Coal India Limited, are necessary and proper parties in the instant writ petition. And since they have been implemented responding writ petition and their head office situated within the territorial jurisdiction of this court certainly can entertain and try the writ petition. So based on, my lord, the head office at here, now, my lord, paragraph 22. I am not reading the entire paragraph, my lord. All paragraphs are, my lord, similar to the argument as I advanced. Here, Adani expert has been, my lord, considered because Kusum was based on Adani expert, my lord. Adani expert is the, my lord, mother judgment in relation to the cause of action.
When 226(2) was introduced,
I will find from, my lord, here.
yes, when
I will get from, my lord, the constitution itself.
226(2) was introduced.
1963, my lord.
Huh?
15th Amendment Act at
1963.
1963.
Are, come on, tell me.
Article 2 initially
226(2) was introduced on
1963, 15th Amendment 1963. The amendment introduced the concept of territorial jurisdiction based on the cause of action. It allows High Court to exercise this power even if the cause of action arose partly or wholly within the jurisdiction. 15th Amendment.
15th Amendment in 1963.
But my lord, the book says otherwise, my lord. কোনো ক্লিয়ার কাট কিছু বলছে না।
ঠিক আছে, ওটা পেয়ে যাবো, ওটা কিছু বড় কথা না, পেয়ে যাবো।
Now, my lord, Rambridge Muchi, my lord, which I have submitted just now, my lord. Here, my lord, the same thing has been discussed. And, my lord, paragraph.
Which one?
Just now I have, my lord, shown to your lordship, my lord.
16 you have placed last paragraph.
Yes, 16. I'm not reading the entire, my lord. Same thing has been, my lord, stated, which I have argued. Paragraph 22. Therefore, the decision of the division bench in the case of Eastern Coalfield Limited,
22.
paragraph
Yes.
22, is applicable in the instant case, especially when it appears that the writ petition was dismissed by the same general manager of Mugma area.
What circular it was?
Circular, my lord, for issuance of passing the final disciplinary authority order of disciplinary authority.
Show me that fact.
Paragraph 30, my lord. Since a circular has been issued from the head office of the respondent and
Okay,
head,
to that
page 30, my lord.
paragraph
Para 30,
13.
30.
30. What was the circular? That I've read, but what was the circular for?
Circular, my lord, since the circular has been issued,
No, what is the circular?
circular has not been quoted here, my lord. But I know that circular is, my lord, for, my lord, for monitoring or, my lord, something for, my lord,
No, that-
guideline for disciplinary procedure to be followed.
Circular is not discussed.
No.
It's only the order of dismissal, paragraph
Order
3.
order of dismissal. And circular relates to, my lord, the my lord, procedure to be followed by the authority. Be that as it may, my lord, circular is not, my lord, the relevant here. Relevancy is, my lord, the headquarter of the
Yes,
issue.
and in case of your headquarter, there is no material cause of action.
Here also the same.
In your case,
the-
after introduction of 226(2), as defined and interpreted by several Supreme Court judgments, it has to be a material cause of action.
In the two
Really
judgments,
doesn't matter where the seat.
in the two judgments of Eastern Coalfield Limited delivered by the division bench. Here, my lord, discussed 226 1 and 2. One is, my lord,
The first one that is relied upon, that was relying upon 61 Supreme Court.
is
Admittedly, 226(2) came after that.
no, Kusumin Got has been relied.
Yes, Kusum 9 and 10.
Kusumin Got has been relied.
No,
And-
relied does not mean that it is considered in its true perspective. The judgment does not show that.
And my lord,
Kusum, yes, the law of land, 9 and 10.
Kusim,
Adani, yes, law of land.
and my lord, the Kolal Bandyopadhyay.
When Kusum and Adani is there,
Kolal Bandyopadhyay is the Eastern Coalfields matter, my lord.
yes, maybe.
Is it? It is res judicata to them to argue against that part. But this is their stand before the Supreme Court.
Which citation?
My lord,
Which citation is Kollan?
my lord, I have shown to your lordship. In Kolal Bandyopadhyay, reported 2008, volume 3 SCC. Kindly see.
Yes.
2008, volume 3 SCC 456. Here the Honorable Supreme Court has relegated the matter before the, my lord, Jharkhand court as the authority who has passed the order is from Mugma. Now, what was the ground? What is the submission made by them at paragraph 6? Kindly paragraph 5. Kindly come paragraph 5.
দেখি পিটিশনারের কাগজ একটু বাদুরকে ডাকো তো আমি কামিং উইদিন
Yes, please.
2008. Curriculum. Yes, I'm coming.
my lord, I have some other judgment to place. My lord, today, may I place or my lord?
Yes, complete.
Now, my lord, that judgment.
Eastern Coalfields, Kullan Banerjee.
Yes. Page 5, paragraph 5.
Yes.
Here also the matter of Mugma area. The went up to Supreme Court. ECL has preferred, my lord, this appeal before the Supreme Court. What is their ground? Paragraph 5. Mr. Onif Sajde, Landed Council, appearing on behalf of the appellant, submitted that it is not a case where sanction of the corporate office or head office was required to be taken. Kindly pause, my lord.
The entire cause of action. Read on.
The entire cause of action having arisen within the territorial jurisdiction of Jharkhand High Court, the Calcutta High Court could not have exercised any jurisdiction in the matter.
The jurisdiction, come on, read on.
The jurisdiction to issue the writ in the nature of mandamus is conferred upon the High Court under Article 226 of the Constitution of India. 226(2), however, provides that if cause of action had arisen in more than one court, any of the courts where the part cause of action has arisen will have the jurisdiction to entertain the writ petition.
Absolutely. So cause of action is the fact, principal fact, deciding factor.
Here,
not only the seat
here-
of your corporate office.
here paragraph 5.
So,
Paragraph five,
Mr. Ghosh, it has to be examined whether that page 48, 46, whatever, those two documents allowing the sanction of prosecution, whether is a material cause of action or not. If that is material cause of action, that is issued from Sectoria, Sectoria will have a jurisdiction. West
Now,
Bengal.
apart from
If
this,
that is not a material part of cause of action, only that being there, no cause of action.
apart from this, I am asking the stay of the inquiry.
Yes.
Stay of the inquiry.
Yes.
Inquiry is being conducted at Bardhaman, at Saktoria.
Seat is no matter. It is the cause of action. Cause of action.
Cause
and
of action, my lord, here, they are conducting the inquiry, which I wanted to, my lord, stay, is at Asansol. Now, paragraph 5 of the judgment says that
Cause of action means what is the material part of it and what will be the effect of it.
now, my lord, the paragraph 5, if you will kindly see, Mr. Onif Sajde, Landed Council, appearing on behalf of the appellant, submitted that it is not a case where sanction of the corporate office or head office was required to be taken. Here, the sanction was taken. Under,
Yes,
under that,
disagree.
So-
but that sanction, whether is the material part of cause of action.
certainly, my lord, material.
According to you, certainly. Let us see.
Now,
Let us see.
the Nawal Kishore, my learned friend has cited. I also cite that judgment, paragraph 12.
So absolutely, 5 and 6, I am agreeable. Kollan Bandyopadhyay.
Yes.
I'm agreeable. 226, 2.
2.
That's the
Two.
that's my view also.
2 and 1 has not been discussed. That's why that part has been discussed in the matter of Jafar Khan by the division bench.
Sir, 1 is your substantive provision, charging provision. Unless you satisfy 1, you cannot maintain a 226. If
No.
you cannot maintain a 226, question of territorial jurisdiction does not arise.
No, my lord. Here, my lord, 1 and 2 are distinct and different and independent.
Absolutely independent.
So
I
if-
am absolutely with you.
Independent. So if I can satisfy the 1, I may not satisfy the 2. If I can satisfy 2, I may not satisfy 1.
No,
Either
2
one.
is absolutely territorial jurisdiction.
Territorial jurisdiction, 1 is for the
So
seats.
if you don't qualify 1, you cannot go up to 2.
No, 1 is for the seats.
1 is the infringement of your right.
Infringement of right. Where
Infringement in addition to 32. So
No.
if an infringement is there within the meaning of sub-article 1, then you can travel up to 2. If you are stuck at 1, the court says, no. Test under 226, 1 is not satisfied. Wherever you file your writ petition is not maintainable. Wherever.
Now, my lord, kindly come Kusum Ingot, paragraph 25. Because Kusum Ingot is to, my lord, read the entire thing, my lord, entirety. Kusum Ingot was based on only 226(2). No one has been discussed. Now, paragraph 25.
Kusum.
Yes.
কোথায় গেল? কুসুমিন বোর্ড।
Here appellate authority is at my lord Saktoria. Appellate authority is at Saktoria. The said decision, the paragraph 25,
Yes, read.
the said decision is an authority for the proposition that the place from where an appellate order or revisional order is passed may give rise to a part cause of action, although the original order was passed at a place outside the area. When a part cause of action arises within one or other high court, it will be for the petitioner to choose his forum.
Absolutely. I'm absolutely with you. I am absolutely with you.
So,
Had this sanction part, page 48 or 49.
not only sanction part, here appellate authority is at Saktoria. Let my landed friend, my lord.
In the facts of your case, if I hold that yes, these two documents, 48 and 49,
No,
whatever,
apart from that, appellate authority, that is the sanction.
that stage has not yet arrived.
Appellate authority,
Today, your stage is sanction for prosecution, disciplinary proceeding has been initiated.
well, if your lordships,
So if I find that sanction is not a material cause of action, Calcutta gone. Calcutta High Court is gone.
if my lord, sanction is, my lord, ignored.
If
If
sanction is held to be a valid cause of action, then you have both
Yes.
Jharkhand and Calcutta.
Or
Then
here,
you can choose.
yes.
But
Now,
if that is no material at all, no material cause of action at all, then the question of West Bengal does not arise.
well, if my lord, your lordship hold, the sanction is not material, then the prosecution, the entire thing will be, my lord, cannot be continued
No.
because the continuation is based on the sanction. Why my why?
Sanction is merely a condition precedent. After sanction, they may not have initiated the disciplinary proceeding.
They have to.
Huh?
They have to.
No,
They have to.
no.
Because sanction,
Cannot be the law.
they,
That cannot be the law.
they have to. In a
No.
case of CBI, my lord, I know the fact, my lord. In a case of CBI, this is not the simpliciter disciplinary action that you committed this mistake, the misconduct is such and such, and you will be prosecuted and you will be examined, and your conduct will be examined by a disciplinary authority or in an inquiry. Here, my lord.
Sir, Mr. Ghosh, sanction is a ministerial job. It is an administrative action.
Oh, my lord. Here, if your lordship kindly go through the charge sheet, if your lordship kindly come, charge sheet then. Based on the CBI investigation, the charge sheet has been issued.
CBI investigation is in Jharkhand.
Yes. So, they cannot issue a charge sheet unless there is a sanction from the headquarters.
Right.
So,
But
if
the basis is CBI investigation, which is
basis is
at Jharkhand.
CBI, and my lord, the basis of disciplinary action is the sanction. Basis of disciplinary action is the sanction.
Sanction, and in any event, your sanction is not in challenge in the writ petition also.
No, I am only praying for the staying of the disciplinary proceedings. Now, what I am,
Staying of the disciplinary proceeding.
till conclusion of the criminal case.
Absolutely.
Now,
Which is the material part of cause of action is the disciplinary, pending disciplinary proceeding.
and where the disciplinary proceedings is being conducted at Asansol.
Huh?
Disciplinary proceedings is being conducted at Asansol.
Seat is immaterial.
Disciplinary proceedings seat is material because disciplinary proceedings, they are conducting the inquiry at Asansol. That is within the territorial jurisdiction of this court, which I wanted to stay.
Your entire disciplinary proceeding is at Jharkhand.
Initiated at Jharkhand, but they are conducting which I wanted to. I am not asking for the quashing of the charge sheet.
So
I am
Can
asking.
it be possible?
I am not.
Can it be possible that the disciplinary proceeding, unless the initiation is bad, to be held bad, hearing will be stayed? Is it possible?
No. That is separate issue.
No, no.
Charge sheet, quashing of the charge sheet is separate issue.
Hmm.
I am not asking for the quashing of the charge sheet. I am on the point of stay of the proceedings. Now, what they are conducting, if your lordships kindly, my lord, borrow the concept or Naval Kishore, that he has opened that, my lord, envelope, cause of action arose. Here also, they are conducting the proceedings because I wrote a letter to them, you don't proceed because the criminal case is pending. They, my lord, did not.
Don't proceed with what?
Don't proceed with the disciplinary action.
Where is that?
At there.
There.
Now, at there. Now, they.
Had the disciplinary proceeding not been there, could you have asked for stay of this?
Now,
So what is the material cause of action?
material cause of action is also the inquiry. Main material cause of action is the inquiry because I asked.
Action is the disciplinary proceeding.
Cause of action
Inquiry
discipline.
is the process within it.
My lord, cause of action not only the disciplinary proceedings. Rather, issuance of the charge sheet is not the cause of action. Issuance of the charge sheet is not the cause of action. Real cause of action is the conduct of the continuation of the disciplinary
Where's that
proceedings.
challenge? You have challenged the charge sheet.
No.
Of course.
Kindly come to
See
my
the prayer. See the prayer.
Kindly come to my
Read the prayer. Read the prayer loudly. What's the prayer?
A writ in the nature of mandamus, commending the respondent authority, including the man such and such, in office to stay the disciplinary proceedings, which is conducting here.
Disciplinary proceeding is in Jharkhand.
No, here they are conducting
That's
here.
Seat. That they're conducting. Maybe
They are
hearing is conducted here.
here.
Hearing.
So my lord,
Hearing.
disciplinary proceedings and the inquiry initiated by the respondent authority arising out of the charge sheet. They are conducting inquiry here.
Absolutely, I don't disagree.
If you
to
stay
it.
that part, because they are, my lord, taking
So
the evidence,
if I stay that part,
automatically, my lord, my purpose will be served.
yes. So for that, what is your material cause of action? For maintaining the writ petition. I am not on merit, Mr. Ghosh.
My lord.
Once again,
My lord.
you are welcome to withdraw the writ petition even now and to file it before Jharkhand High Court.
No. My lord, I will
Yes.
pursue here, my lord.
So I am not on merit of your disciplinary proceeding. I am only on territorial jurisdiction today.
Territorial jurisdiction, my lord. If your lordships kindly read my prayer to stay the disciplinary proceedings and obligatory inquiry initiated arising out of the charge sheet. Now
No
they
doubt about that. The
now
inquiry
they
is
are
going here.
now they are initiating the disciplinary proceedings by appointing a management witness. Who are they? They are from headquarters.
If they come from Chennai,
No, it's a bundle of facts. Bundle of facts, not only
absolutely
bundle of facts. Now,
bundle of facts, which is material, integral,
and apart
not all the facts.
and my lord, if your lordship see the communication made by them.
Suppose they don't produce witness, inquiry
No,
ultimately on merit may fail.
no witness.
No.
There is no question of witness. They are appointed management representative to represent the management.
All right.
They are representing.
Very well. Let's say the management representatives are not appointed.
They appoint.
What will happen?
So they appointed and they are conducting.
Mr. Ghosh, what will happen? Answer to my question.
Then proceedings will not be continued.
Yes, proceeding will fail. In limine. In limine proceeding will fail. So the proceeding is there. Proceeding will be there. It may not succeed. It may fail. So what is your cause of action? Material cause of action, not the appointment of management representative.
Apart from the appointment, what is their communication to the headquarters? Kindly see. They are if your lordships rely the Naval Kishore, then their communications will be the subject matter of the issue here. Kindly see, because headquarter is, my lord, the authority who is the dictating the, my lord, disciplinary.
Show me Naval Kishore, what you want.
My lord.
Yes, 2014-9.
Yes. Paragraph 12. Paragraph 12, Kusum Ingot has been, my lord, referred to. The meaning of what? Cause of action with reference to clause number
Which
20,
paragraph?
paragraph 12. In Kusum Ingot and Alloys Limited, Union of India, this court elaborately discussed clause number 2 of the 226 of the Constitution of India, particularly the meaning of the word cause of action with reference to section 20C of the such and such. Although in view of the section 141 of the CPC, the provisions thereof would not apply to the writ proceedings, the phraseology used in section 20C of the CPC and clause 2 of the 226 being in perimetria, the decisions of the court rendered on interpretation of section 20C shall apply to the writ proceedings also. Before proceedings to discuss the matter.
Yes, go slowly.
Before proceeding. Before proceedings to discuss the matter further, it may be pointed out that the entire bundle of facts pleaded need not to be constituted a cause of action, as what is necessary to be proved before the petitioner can obtain a degree in a material facts. The expression material facts, also known as integral facts.
Utterance.
Yes, keeping in view of the expression used 22 of the Article 226 of the Constitution of India, indisputably, even a small fraction of cause of action accrues within the territorial jurisdiction of the court will have the jurisdiction in the matter.
Accept it.
Fraction.
I accept it.
Fraction is there.
I accept it. I accept that if a small cause of action is
Yes.
there,
Yes.
cause of action is there.
Now, Madam, kindly come to my.
This small cause of action, what is? According to you,
Yes.
the issuance of sanction and appointment of management representative.
And my lord.
And the seat.
And the
Seat is not the cause of action.
And the continuation of the disciplinary proceedings are here.
Yes, that is not the cause of action. That is not the cause of action.
And
Cause of action is, according to you, the sanction from West Bengal, appointment of management representative from West Bengal. That is according to you cause of action. Those are not material cause of action.
Apart from this, my lord, if your lordships kindly come page 48
Of
writ.
Yes.
Noble Kishore will squarely apply in view of the service of the letter at here.
I admit Noel Kishore applies.
1
I
and 2.
admit.
1 and 2.
Yes.
No, kindly come.
Read with Kusum.
Yes, yes. Kindly come, my lord, the page 48. Copy to.
Yes. Up to you, sir, because up to you. So, sir, I am also hearing. Because after one, there will be original site. And then if original site list collapses, then I will take up the appellate site. I don't release anybody, but if ultimately parties are not there, I don't take up. Normally, I pass it over for the day. Yes.
Well, page 48.
Yes.
This is the letter issued by the agent / disciplinary authority, Sampur B. Colliery Lokimata Group of Mines at Mugma.
But if the parties are not there, I pass it over for the day. That I cannot assure, sir. That no, I can pass it over for the day. That I will do. I will pass over whoever is not there. That I cannot assure. That I cannot assure. Because that is not within our hand nowadays. It's controlled from Pune. Suppose writ petition number 500 is yours. It's today 9/17. But if some matter is directed to appear tomorrow, which is writ petition number 400, that will automatically go up. So that is not within our control. No, but the thing is that is not within our control. It is now being controlled absolutely by the central system, which is at Pune. No, even though the direction is not there, suppose a file comes from department. WPA 400. That will get the precedence, even if I don't direct. If it is 500, your matter is 500. 500 2025 will go down and 400 2025 will go up. Yes, so if the 400 of 2025 comes, it will go above your 500. That we don't have any. Previously, that control was there, but nowadays it is not. It's an all India control. Yes. Yes, but if after this, if time permits, then whatever direction I will. But nowadays, I have given preference to the motion, not the assigned event. See the list, see the list. See the list, follow the instruction. Sir, I have given instructions in my list. If you don't follow, sir, what do I do, sir? Next, yes. Or if you say before vacation, I will not give preference to motion, I am fine. I will not give preference to motion, I will give assigned hearing, assigned matters, forwarders. Sir, whatever is the instruction, sir, I have given. If there is any difficulty, what to do? I have given preference to the motion because first 15 days I will not be sitting in September. I have circuit. So effectively, this bench you will get for 15 days. For 7-8 days this month, 10 days in September. Jalpaiguri. So I have to give justice to the motion. I try. That's why I gave that note. What to do? I can try. This much I can say. And of course, the cooperation I get from the bar is fantastic. Always. Always. Assistance and cooperation. Absolutely right. I also admit that. I say yes, but what to do, sir? We have also our limitations on this side. That's the difficulty. Yes, I appreciate that. Yes, Mr. Ghosh. But normally I don't do any harm to any matter. If somebody is not there, I'll pass it over for the day. Yes. Yes.
Page
Mr.
48,
Ghosh.
my lord.
Page 48.
My lord.
Yes.
Copy 2 at bottom, my lord, if your lordships kindly come. Here, my lord, letter issued by my lord the sample.
Just let me tell you,
My lord.
this copy 2 will not give you cause of action.
No.
As to the content of the letter, where from it is issued, come to the content of the letter, to whom it is addressed. Sir, if it is copy to your High Court advocate, having chamber at 6 Old Post Office Street, and you take the plea that cause of action is here.
No, entire letter. Entire letter, my lord. Kindly see, my lord, the agent, disciplinary authority, Sampur B. Colliery, Lokumata Group of Mines at Mugma. Now, here the two persons has been appointed by this letter. One is the inquiry officer, and another is, my lord, the management representative.
Correct.
Management representative from here. Now, the copy 2 as to why I am telling, my lord, these two persons, these persons were allowed the proceedings to be initiated.
So copy to your advocate at 6 Old Post Office Street will give you a cause of action.
The main address is the body of the letter.
Please have some limit.
Very well. Now,
have some limit of argument.
Now, my lord, the Kusumin court, I would like to show some paragraphs, my lord.
Yes. Do that.
Before that, if your lordships kindly come now, Nawal Kishore.
Nawal Kishore.
Paragraph 17.
Hey, देखिए.
Paragraph 17, my lord.
Hmm.
We have perused the facts pleaded in the writ petitions and the documents relied upon by the appellant. Indisputably, the appellant reported sick on account of the various ailments, including difficulty in breathing. He was referred to the hospital. Consequently, he was signed off for further medical treatment. Finally, the respondent permanently declared unfit for sea service due to the dilated cardiomyopathy, heart muscle disease. As a result, the shipping department of the government of India issued order dated such and such, cancelling the registration of the appellant as a seaman. A copy of the letter was sent to the appellant at his native place at Bihar. Why I wanted to show this, my lord, here also, based on the service of the letter, the jurisdiction was assumed. The copy of the
Kindly leave the last line.
letter was
of
sent to
that
the appellant
paragraph.
at his native place
Therefore,
Bihar.
considering, read it, prima facie, therefore considering.
It is further evident that when the appellant was
The last last one sentence of that paragraph.
prima facie, therefore, considering all the facts together, a part of fraction of cause of action arose within the jurisdictions of the Patna High Court, where he received a letter of refusal disentitling him from disability compensation. So, my lord, here also cannot be deciding factor according to the, my lord,
So that is
you.
why it was a jurisdiction.
That is not the integral part, because the cause of action arose at, my lord, Jammu. Even then, the Honorable Supreme Court has said,
All right. You
well,
make your
kindly
sum-
consider that part. The disciplinary authority was at Jammu, appellate authority was at Jammu. Only communication was made to the Bihar. The Honorable Supreme Court has said,
Where he will know? Where will he know? When he will know that he is disentitled or dismissed? Where from? The letter?
letter.
The letter received at Patna?
Is it an integral part of the
Of
cause
course.
of action?
200%. 200%. Had that letter of dismissal not been there, would there be a proceeding?
Then, my lord, the service of the letter at here, issuance from here,
Issuance will not give you cause of action.
issuance from here, the
Very well.
proceedings
Complete,
is
sir.
proceedings is continuing here.
Complete your argument.
Now, paragraph 10, I have shown to your lordship. But 10 of Kusum Ingot, my lord, I have shown to your lordships.
Yes, 9, 10.
9, 10, I have
And I rely on 9 and 10.
9, 10, 6, 7 and 8 also, my lord, may kindly be, my lord, looked into.
Kusumin got 9, 10. Nawal Kishore 12. I hope you have completed.
No, my lord, the paragraph 6, 8, my lord,
Of
Kusum Ingot. And another judgment, my lord, regarding, my lord, the
show me. Cite it.
Kusum Ingot, my lord.
Oh, yes. Kusum we have. Para?
6,
Yes.
6, 7, 8, 9, 10.
Absolutely, I'm with you. Read 6. I'm with you.
Cause of action implies a right to sue.
Huh.
The material facts which are imperative for the suitor or allege and prove constitute the cause of action. The cause of action,
Absolutely, I'm with you.
cause of action is not a defined in statute.
Absolutely,
has-
I'm with this.
However, been judicially interpreted and to mean that every fact which would be necessary the plaintiff to prove if traversed in order to support his right to the judgment of the court. Negatively put, it would mean that everything which if not proved give the defendant an immediate right to judgment would be the part of the cause of action.
I agree.
Its importance is beyond any doubt.
Take microphone.
Its importance is not beyond any doubt. For every action, there has to be a cause of action. If not, the plaint or the writ, as the case may be, shall be rejected summarily. Importance. Its importance is beyond any doubt. For every action, there has to be a cause of action. If not, the plaint or the writ petition, as the case may be, shall be rejected summarily. So here, my lord, every action there is a cause of action. Here, action initiated from here.
Every action, read on, of the cause of action.
Every action, there has to be a cause of action.
And
If
that
not,
what is cause of action? 9 and 10. Read
Co-
9 and 10. Those are cause of action.
cause of action, my lord, it's also part of
Bundle
the
of facts.
bundle of facts. Here
All
also,
the facts.
all the facts,
So not all the facts are cause of action.
bundle of facts,
Some of
some
them.
of them. Here, my lord, first is, my lord, issuance of the sanction letter.
No cause of action according to me.
Second thing, my lord, the appointment of the management representative from
No
here.
cause of action.
Very well, my lord. The service of the letter to the headquarter,
Tomorrow at Temple Chamber.
maybe in a check bounce case, my lord.
Temple
In
Chamber.
check bounce case, my lord, both places are, my lord, permissible. 138. Now, my lord, even in a defamation case,
কি অবস্থা? কোথায় নিয়ে যাচ্ছি আমরা জায়গাটাকে? কিছু বলার নেই। Yes.
now, my lord, service,
No, I am sure you have completed.
no, one
Okay.
judgment regarding the, my lord, binding precedents, I would like to show, because
Here and now, here and now,
that,
here and now.
because division bench judgment has
Mr. Ghosh, nothing.
binding precedent.
Enough. Yes, binding precedent, you make your submission, I am recording. If you have, you give
The
it
two
to me.
division bench judgment. Otherwise, your lordship has to refer before the, my lord.
No, this
The
is not the case. This is not the case.
I will study. I will, my lord, only, my lord, give me liberty to cite that judgment. I will not argue.
Here and now.
Today, I am not. I
Mr. Ghosh.
only.
Sir, after 3 hours.
No. I will not argue. Only I will hand over to your lordship's court officer the judgment and paragraph
No.
of the Honorable Supreme Court.
No.
When-
I appreciate.
If your lordships disagreed, the order
I'm
division
disagreeing. I will follow Supreme Court.
disagreed,
Follow Supreme Court.
which has been considered by the division bench.
Yes.
Now, if your lordship disagreed,
I'm not disagreeing. Kindly hear the difference. I will follow Supreme Court. I will follow
two division bench
Nawal Kishore.
and two division bench.
Yes, who have followed those.
Yes.
And I will follow those two. So no difference.
And two division bench, out of which, my lord, this Nawal Kishore as well as, my lord, Kusum God has been followed. No, not Nawal Kishore has been followed. Kusum God has been followed.
Absolutely. And I will
And
quote,
Kullan Bandyopadhyay has also been followed.
I will quote Nawal Kishore and Kusumin Goat, which are followed.
Then, my lord,
No question of defying. I will agree.
but
I
your
will
lordship,
abide.
the binding precedent division bench order, my lord, this is binding upon them. They cannot.
It is also binding on me.
And, my lord, single bench judgment, which my learned friend has referred, that is also in my favor.
Mr. Ghosh, I will deal in my own way. If I find that no cause of action, if I find. Yes.
And, my lord, the notes I will, my lord, file, my lord.
Only in reply, my lord, kindly see their grounds, or whether, my lord, they have challenged the seats and
You
all.
complete tomorrow. You complete tomorrow. When you will file your note?
Give me some time because.
Yes, that I will give you.
Not.
I will give you. But I want to conclude it.
Yes.
Conclude tomorrow. Ashun. Mr. Partho Ghosh, Learned Counsel appearing for the petitioner, has concluded his submissions.
Only one judgment I will, that judgment.
Point of maintainability. Very well, you come tomorrow with the judgment. But he will cite one or two judgments on the proposition of binding precedents. He shall place those judgments tomorrow and finally conclude his submissions. Paragraph. Mr. Arifin shall then commence his submissions only on the point of law, insofar as the maintainability of this writ petition is concerned, within the territorial limits of this court, and shall conclude tomorrow. The writ petition shall appear under the heading kishe ache এটা?
For order.
For orders, within bracket top, tomorrow. তারিখ কত? 22. বাট কালকে আগে কন্টেন্ট ম্যাটার লিস্টে থাকবে, তারপর এটা। I don't think before vacation. I kept it, but let me see.
They have taken the time, my lord.
Very well, I don't mind. I will take up another 3 days before vacation.
I will be only on merit. There is no jurisdiction.
Sir, you may not take, you may take 3 minutes, but I may take to consume that 3 days.
Your lordship will take 3 minutes. Your lordship will
All
take
right.
3 minutes. But
All right.
Item number 4, my lord. On my insistence, this matter.
I don't mind, sir. I don't mind, but it will appear very well. কি বলেছি? কি বলেছি? না, 4 তো আলাদা আছে। তো ওটা পাস ওভার করা থাক, ওটা কাল থাকবে, ওই পজিশনে থাকবে। চলো। Tomorrow, কত? হ্যাঁ, August 22, 2025. ঠিক আছে। ওই মামলাটা ডাকুন, আমি পাস ওভার ফর দ্য ডে করে দিই। আর যদি আজকে কোলাপস করে অরিজিনাল সাইড, we will take it up.
Kindly may not make it tomorrow, my lord, then.
Which one?
4, because
No.
no,
If it collapses, I will take up tomorrow. I will take up today itself. কি বললাম, আইটেম নাম্বার? পাসড ওভার? না, পাস ওভার করার দরকার নেই, থাকুক। যদি কোলাপস করে অরিজিনাল সাইড, I will take it up.
Otherwise, it will maintain retain its possession, my lord.
It will appear tomorrow otherwise.
Allow with it, my lord. Kindly only that much of.
Sir, let me hear it first. Let me conclude it. Then I will start hearing you. How long will you take? You will take. Other side will take.
my lord, next matter may be pass over for the day, my lord.
I don't mind,
But
sir.
next matter may be pass over for the day, my lord.
Which one?
At number 4.
No, sir.
Because tomorrow matter will be taken away along with
Yes,
this.
no. If I conclude the original side, I will start appellate side. I will take up. I will take up. একটু সরিয়ে দাও। লাস্ট অর্ডারটা দেখি।
ও আচ্ছা। আগের দিন এত কিছু বললি, কিছু তো লেখা নেই।
না কি লেখা থাকে, লেখা তো নয় বটে।
আগের দিন সিদ্ধার্থ তার কত কিছু বললো, যে একটা নোট ফোট বানিয়ে আনলো।
If you wanted to see the Supreme Court order,
Yes. কত তারিখ? Wait. Yes, sir.
that's the order, Lordship wanted that order.
এটা নিয়ে নাও। Yes.
I should only deal with the points the Advocate General
The
urged in
microphone,
last
sir.
ticket.
Microphone.
I should only deal with the points urged in the last ticket by the Advocate General, nothing more.
He has referred to one judgment.
One judgment, no, the section, whatever, only that point and whatever, one line, whatever is mentioned, I'll just answer those, nothing else. I'll mention nothing more. Now, I want to kindly take the Arbitration Act, section 12. First period, 12.1, grounds for challenge.
Grounds for challenge.
Yeah, challenge. 12.1, when a person is approached in connection with his possible appointment as an arbitrator, shall disclose in writing any circumstances, they were A and B, my lord, are what is mentioned. I'm not troubling your lordship with that, because my lord, he's not relying on any of the items, so my lord, I'm not bothering with. Kindly, my lord, come to my lord. Explanation 1. Explanation 1. The grounds stated in the 5th schedule shall guide in determining whether circumstances exist which give rise to a justifiable doubts as to independence of impartial arbitrator. The disclosure shall be made by such person in the form specified. So the guidelines are in 5th schedule. Then subsection 2. This applies in our case, according to the Advocate General. An arbitrator from the time of his appointment and throughout the arbitral proceedings shall without delay disclose to the parties in writing any circumstances referred in subsection 1 unless they have already been informed of them by him. So in this case, there is no allegation of something happening at the time of appointment. What has transpired during the course of the arbitration, so under subsection 2, if it applies, the arbitrator should have disclosed. The arbitrator should have disclosed whatever, my lord, the Advocate General says he should have disclosed. Then 3, an arbitrator may be challenged only if circumstances exist that give rise to justifiable doubts as to independence or impartiality, or he does not possess the qualifications agreed to by the parties. B doesn't apply. If at all, my lord, A can apply.
Yes.
Then, my lord, 4, a party may challenge an arbitrator appointed by him or his appointment accepted only for reasons which becomes aware after the appointment, not relevant in our case. This was a presiding arbitrator, not appointed by any of the parties. So 12, 1, 2, and 3. Then, my lord, comes 5. This is important now. What is 5? Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or subject matter of dispute falls any of the categories specified in the 7th schedule shall be ineligible to be appointed arbitrator, provided the parties may subsequent to disputes having arisen between them waive the applicability of subsection by exclusive agreement writing. Now, subsection 5 only applies to 7th schedule, not the 5th schedule. And 2 are different. And I'll show that. The 5th schedule is a question of disclosure in the case of justifiable doubts by the arbitrator. He thinks that he should disclose. 7th schedule is nothing about disclosure. It is ineligibility. He can't be appointed at all. Advisedly, the legislature had made 2 different schedules, and the 2 are not identical. I'll show that. And the difference will follow, my lord, from subsection 13 and 14. Look at 13 now, challenge procedure. One is subject to subsection 4. Parties are free to agree on a procedure for challenge, not applicable in our case. Then 2, failing in agreement referred to subsection 1, a party who intends to challenge an arbitrator shall within 15 days after becoming aware of the Constitutional Tribunal or after becoming aware of any circumstances referred to in subsection 3 of section 12, send a written statement of reasons so and so. The 15 days will be relating to subsection 12(3). As soon as the party gets to know, he must within 15 days make a challenge.
No, 13(2).
13(2). Failing in agreement, party intends to challenge.
13(3) in the event of 12(3). 13(2).
2, 11 of 12(3).
In the event
of nothing to do with 5.
13(2). And not 12(5).
Then, my lord, 14, subsection 4, sub 3, my lord, unless the arbitrator withdraws, the tribunal will decide on its own on the challenge. That's the first level. After the decision of the challenge, then subsection 4, you will continue with the arbitral proceeding. The challenge under any procedure agreed by the party under so and so, and the subject is not successful, tribunal shall continue the arbitral proceeding and make the award.
But here that stage has not arisen at all, because they have, according to you, they have not taken the point before the tribunal.
That's right. Therefore, they can't do it anymore. And this is, the argument was not exhaustive. I'll deal with that point. Whether I'll come, let me show the schedule, then I'll tell your lordship. Then, my lord, 5 is, if an award is made, then, my lord, setting aside will follow. Then 5 more question of fees. So that point has to be taken up at the time of setting aside the award, if at all. The challenge has failed. Now, if the challenge has failed in 15 days, that point goes. It's only more a ground of challenge if there is a doubt. Not sub 7 schedule. That is something else. And look at 14 now.
What did you say?
7 schedule, Mullah, there is no question of challenge. 7 schedule is he is not eligible to act at all. And I'll show that. It's clear from the judgments I've already cited. You can't go to the tribunal anymore. If the argument is you're not eligible to act at all, then you don't go to the tribunal.
7th schedule makes the arbitrator ineligible.
That's right. Then, if you become ineligible, then the party no point in party going before the tribunal.
Correct.
And saying you're ineligible. But a party goes in the case of 5th schedule, where it is a challenge.
But here no challenge was there.
No argument has been advanced that he's not eligible. They can't do it anymore. That stage is over. Look at 14.
Yes.
Mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes de jure de facto unable to perform his functions so and so without from office. Then if a controversy remains concerning any of the grounds, clause here, subsection 1, party may only otherwise agreed apply to the court to terminate the mandate. They withdraw his office, that I'm not troubling your lordship. So, if there is a 7th schedule point, then the party moves the court on section 14 that is not eligible to act at all. Then he has to show the ground on a 7th schedule. The legislature thought any allegation of bias is sufficient. It was said so. They indicated not.
Sir, one second. So in case of 14(1)(a),
Yes.
the 7th schedule will apply.
He de jure unable to function.
Ineligibility.
So, what is the step now? There, a list is given. But can be justified by doubt. Arbitrator knows. He discloses. He does not disclose. Party comes to know. 15 days he can put a challenge to the tribunal. Challenge decision is against him. Proceeding will go on. Award will be passed. Party will challenge the award on that ground, which will not be available unless he raised the challenge in the first place in 15 days. That goes.
No, so if that 15 days goes, or in the instant case, they have never applied. For to speak of 15 days, they have not applied at all. In that case, according to you, those points, if at all they will take at the time of 34.
Where then, whether it will be available or not, that's a different matter. I'll argue then, not now.
Absolutely, that's a different issue. Whether
no longer available until that stage.
Whether the points will sustain or not, whether their objection will sustain or not, that has to be decided at the 34th stage.
Can't be taken before that. It's not available there. Available only section 14. That is gone because award has been passed. So these wild allegations
if at all, according to you, it should be at the 34th stage.
Because the section says so.
That's right. So there then on merit it should be had.
My argument then maybe is exhaustive. You're waived, you can't take it anymore. But I don't have to do it now.
That stage we have not yet reached.
I'm grateful. That point is not available at this stage. Before the final hearing of 34. It can't be taken at any point of time. There's a scheme of this act. You do it within 15 days, fine, well and good. If you don't do it, award is passed. Take it up at that time. We shall see what will happen. Now, kindly take the 5th and the 7th schedule now. See the difference.
Fifth schedule refers section 12(1)(b). What you will see, my lord, section referred to is 12(1)(b). Following grounds give rise to justifiable doubts, independent impartial arbitrator. Relation list is given. 34 items.
Yes.
Now come to 7th schedule. Refer section 12(5). It is not a 12(1)(b) list, it's a 12(5) list. And see the list, relationship with parties of council and Millard, they'll only Millard 19 items here instead of 34. So Millard, there's a clear Millard bifurcation Millard between eligibility and the right of Millard obligation of disclosure. A point asked here is obligation of disclosure. And that Millard obligation, if not having been performed, the period of challenge has now gone, award has been passed, it can only be raised at the stage of section 34 and not before, if at all.
If at all. That's a different
I make no concession on that.
That's a different issue. That is again
Millard,
a matter
why
of
it becomes
argument.
exhaustive? The reason is very simple. An obligation is being cast by statute upon the tribunal to make a disclosure. An obligation is cast upon by the statute on the tribunal to make a disclosure. The tribunal must know when it has to disclose. It's an obligation cast on the tribunal, onerous obligation.
That's
He can't decide on his own.
They are saying that it's an onerous obligation. They say that, which the arbitrator has failed to do.
But that obligation has to be spelled out from 5th schedule.
Yes, 5th or 7th.
Otherwise, he will not know. Not 7. 7 not a matter of disclosure at all. Disclosure only is 5 and not 7.
Disclosure is of 5.
7
is
means ineligible. Disclosure is of no value. If a party gets to know, he applies under section 14 and terminates the mandate.
So 7th schedule serials can be taken by the parties only, if the party is applied.
That's right. Tribunal has no role.
No.
Well, tribunal can't say I'm not eligible to carry on. Kindly appreciate me. Tribunal can't.
Just fine clarification. 5th schedule is according to you upon the tribunal to disclose. And that is their allegation. Tribunal has not done so. If the tribunal has not done so, Mr. Sarkar, according to you, they ought to have come within 15 days, failing which they have to wait till the stage comes under 34. That's your case. Yes, sir. Now what you
At that stage, I will urge that even the 34 stage is over, unless you take within 15 days, you waived your right.
That's a different.
That's not relevant. But 7th schedule has no application, 12(5) has no application here. My learned friend's case is on 12(5). And I shall deal with that. This party cannot go and tell the tribunal you're not eligible to go on. Party will move the court.
Fifth schedule, if at all that was applicable for them, they missed the bus. That's
right. And section 13 will apply. Arbitration will go on. Award will be passed. They have another challenge at that stage. We shall see what will happen. Your Lordship can't consider this point now at this stage before the final hearing of 34. Apart from the other points we've argued, I just mention them briefly because my learned friend has made one-line arguments. I'll just answer them in one line.
Yes.
Now, he cited the Delhi case. 2022 SCC Online Delhi, 1651. First paragraph of the judgment. The Lordship got it. Arey.
Dr. Sahib last din jeta dilen, Dr. Sahib a bunch. পিটিশনারের বেঞ্চ। এটা না, এসসিসি অনলাইন দিয়েছে একটা। হুম,
Well, take the first paragraph.
এইটা সরিয়ে দাও।
First paragraph. The petitioner has filed the present petition on section 14(2) and 15. You got it, man. It's a 14(2) and 15 application. Inter alia praying mandate of the sole arbitrator Subhash Chandra Batra be terminated. See paragraph 2. The petitioner claims the arbitrator is ineligible to act as an arbitrator by virtue of section 12(5) related to the parties and they have not entered into agreement zones. So, this is not relevant for our case.
The petitioner claims that the arbitrator is ineligible to act as an arbitrator by virtue of 12(5). So the petitioner has taken out that application, took out that application.
You need pendency of arbitration.
That's precisely
Correct.
before the tribunal.
No disclosure point here. And my lordship will find in paragraph 4, the Delhi High Court points out exactly what I have submitted to your lordship. Paragraph
One second, sir. Paragraph 4.
Yes.
Yes.
Well settled, the section 12 and 13 of the So Act provide mechanism regarding challenge to the appointment of arbitrator. Party challenging the appointment would necessarily have to continue confine itself to the scheme in terms of section 13(1). It mentioned must confine itself to the scheme. 13(1), parties are required to follow the procedure. 13(2) provides failing any so-and-so, party who intends challenge required to find written statement so-and-so is laid down here. Exactly what I have showed your lordship. Now see, my lord, paragraph 5.
Paragraph
5. My lord, judgment, my lord, of division bench, my lord, is quoted. On a reading of section 13(5), the legislative intent becomes amply clear that Parliament did not want to clothe the courts with the power to annul an arbitral tribunal on the ground of bias and intermediate stage. Note this. He is relying on this case. Therefore, my lord, could not have been done until the award is passed. Not under section 14(5) or 15. That's what the division bench says. Then the act enjoined immediate action.
Sir, 1 second. All right.
Then, my lord,
the act enjoins.
That's right. Kindly come to my lord, paragraph 8.
No, let's read it.
The act enjoined the immediate articulation of a challenge to authority on arbitrator on the ground of bias, tribunal itself, and thereafter ordains the argument of challenge might be raised against the objection of 34. Courts have to give full efficacy so and so when they are. So bias, as my lord, followed section 13(5). If my lord, 12(1) is to apply. Then my lord, paragraph 8 is important. The Supreme Court case, my lord, is considered. This court has considered the scheme of the amendment, section 12 and 14 of so-and-so in HRD Corporation. That was a Delhi judgment, my lord, which was, my lord, affirmed by the Supreme Court. And found that 12(5) stands on different separate footing than the scheme which I arbitrated in the 12(3). Kindly note that. 12(5) is different, my lord, from 12(3). The court held that a person who is ineligible to appoint an arbitrator will ipso jure not have the mandate perform such functions, he would lack the inherent jurisdiction to act as an arbitrator. In such a case, not necessary party challenging the appointment follow the procedure under Section 13, open to seek under Section 14, said we upheld the Supreme Court and HRD Corporation. So it's very clear. The law is rather clear. So if
What is this HRD citation?
Supreme Court, my lord. I thought the Lordship wants I give the Supreme Court judgment to your Lordship, I have it. But this is a Delhi judgment, my lord, affirmed by the Supreme Court. I'll give you Lordship Supreme Court judgment. I have no objection. But since this case relies on it, I'll show it to you, Lordship. Now, my lord, I'm not citing a new case. It's only because referred to, I can give it to your Lordship. Then it goes on in the facts of this case. Then I don't trouble your Lordship with the facts. At paragraph 20, my lord, you filed under read with 12.5 to recuse, asking the arbitrator to recuse. But he is someone's brother-in-law.
Application was filed.
Yes, to recuse.
So
Not for disclosure. Give it up.
give it up.
Need not have filed, but say give it up. In case
The
he's got
seventh
some-
schedule.
In 7th schedule. In case he has some sense.
7th schedule. Because you are ineligible.
If I Lordship see paragraph 9,
So because the give it up means you are ineligible,
please
so give it up.
Yes,
7th
no,
schedule.
anyone my lord, can approach a tribunal and say, don't take up this matter for ABC. reason.
Right. So the
But my
application.
lord, paragraph 9, Lordship will see, my lord, the argument is only on the ground of section 12.5. That was the argument.
Read on.
During the course of the proceeding with P. Nagesh, learned senior counsel representing the petitioner considered the present petition would not be maintainable in so a petitioner apprehension regarding so and so concern, confined the present petition to seek relief only on the ground by virtue of section 12.5, I will be ineligible to act as an arbitrator.
Those points were raised. First,
12.5. 12 was not raised. He said 12 considered, 12 will not apply. Disclosure will not apply.
but additionally, those were raised
Yes.
during the
Yes.
arbitration proceeding.
Yes, before the arbitrator.
That's right.
Then my lord, it goes on, and if your Lordship will kindly come to the finding part, arbitrator was related, and reasons and conclusion, Lordship will find that paragraph 24.
Yes.
This is also very important. At the outset, it is also relevant to note that in applicable to the arbitrator, petitioner has unequivocally stated not cast any aspersion on the integrity character of the arbitrator. Well, same position here. Not only Murad, he is not eligible. Sought the recusal solely on the ground ineligible to act as an arbitrator because they were related. I believe, my lord, the Advocate General
As I
submission-
said, he had sought his recusal solely on the ground that he was ineligible.
So, my lord, I respectfully submit, my lord, the same argument is advanced here. No charge was made on the integrity of the character of the arbitrator.
Yes.
Only ground was, look what he has done. He's made it, my lord, he should have disclosed.
No charge of coercion, corruption.
Corruption or fraud.
No, they say fraud.
Fraud on
They
the
say-
ground of bias.
That's
no
right.
fraud otherwise.
No.
I
They
deal with
say-
that point.
They say fraud includes bias. That's their case.
Now, let's look at paragraph 25. In the aforesaid context, the questions that fall for consideration of this court are whether the arbitrator is ineligible to be appointed under Arbitration section 12.5, and if so, whether the petitioner waived his right to object to such an ineligibility. Then 12.5 is quoted. Then, my lord, 7th schedule is considered. Nothing about the 5th schedule. Now, kindly see what paragraph 34. He is going to consider the 5th schedule. Sorry, 7th schedule. Then, my lord, paragraph 35 says 7th schedule is not exhaustive. Nothing about the 5th schedule.
No, but 5th schedule, why you are harping, sir? Mr. Sarkar, because 5th schedule is for the arbitrator to disclose.
Very exhaustive or not? Here, my defense cited this case to say the 5th schedule is not exhaustive. The judgment is concerned with 7th schedule, not the 5th schedule. The charge was he was a related party. Relationship with the parties. Relationship described in 7th schedule as spouse, sibling, and so on. The court said he is not one of those. No other relationship will be there. Well, the corporate scheme is very clear.
Yes.
So, my lord, this case has no application in my submission to the argument which I made that 5th schedule is exhaustive unless you can point out which item of 5th schedule is attracted. Arbitrator has no obligation to disclose. Apart from the point that within 15 days, no challenge was taken, no challenge can be taken now. Whether it can be done as a final hearing of 34 or not, my lord, I'm not answering that question. Not relevant. Can't be done now.
Yes, that's not relevant at this stage.
Now, my lord, I had cited which had not been dealt with. I'll come to my lord, voice Chalpine and the other case, my learned friend says, which is overruled voice Chalpine. But I had cited Chennai. I had cited a case, my lord, Chennai Metro, not dealt with. It's in your lordship file, lordship will find it, my lord, copy site, date double 2023 SCC Online, Supreme Court 1370.
Copy site 2023
SCC Online SC.
1 second.
2023 SCC Online SC 1370.
13.7.
2023.
Yeah. Yes.
1370. Sir, cited on
1370.
937. 1370.
1370.
March.
Wait.
Site
Yes. Yes. Go.
Then lordship will see, my lord, here. An award was passed in section 34. That lordship will find, my lord, in paragraph 2.
This is for what proposition?
This is, my lord, that section 5012, my lord, read with 50 is exhaustive.
Section
12, my lord, section 12, read with 5th schedule is exhaustive.
Another thing, Mr. Sarkar, I'm hearing 36.2. They say waive the deposit. The language and expression used prima facie satisfaction.
I'll come to that.
Prima facie satisfaction.
Fraud or corruption.
Fraud or corruption.
Nothing else. Well, Lordship permits Mr. Sarkar to cite. I just sit for 2 minutes. Please go ahead.
You're feeling uncomfortable?
No, I'm comfortable. I need to. I've been advised not to sit for 2 minutes after this. But I believe I have at my age what is called
Hypoglycemia.
But it's called orthostatic hypotension, whatever it's called. Standing for a long time without arguing this matter may create a problem. That's what I've been advised.
Whatever way you are comfortable, you do.
After this, let him face his case.
But among the paragraphs cited, Lordship, by Mr. Sarkar was paragraphs 30 and 32. Now, Lordship will see that is at internal page 11.
30.
Yes. Lordship will see that the judgment, the new case which was cited by the Learned Advocate General, relies on the decision of the Honorable Supreme Court in HRD. Now, Lordship will see that the paragraphs which were placed by us in this judgment, which is also a judgment of the Honorable Supreme Court, this dealt with both Voestalpine as also HRD, and that clarified the scope of the same. Now, if I may kindly place, Lordship, from paragraph 29 onwards, because that deals with Voestalpine. Having regard to the above statutory position, it would be necessary to consider the judgment cited. The first in this series would be Voestalpine versus Delhi Metro Rail Corporation, where, taking note of the amendment made to the Act in 2015, the court underlined that it was with the objective of to induce neutrality of arbitrators, especially their independence and impartiality, that the Amendment Act of 2015 was introduced. The amended provision was enacted to identify the circumstances that gave rise to justifiable doubts about the independence or impartiality of the arbitrator, and in the event any of those circumstances exist, the remedy provided is under section 12. Now, Lordship will see paragraph 30. The next case, HRD Supra, needs to be closely analyzed. The court first examined with some detail the background of the 2015 amendment, the circumstances leading to it, which is the Law Commission report, and eventually the amendment. The court then significantly ruled as follows. Lordship then set out. The enumeration of grounds given in the 5th and 7th schedules have been taken from the IBA guidelines, particularly from the red and orange lists thereof. The aforesaid guidelines consist of 3 lists. The red list, consisting of non-waivable and waivable guidelines, covers situations which are more serious and serious, the more serious objections being non-waivable. The orange list, on the other hand, is a list of situations that may give rise to doubts as to the arbitrator's impartiality or independence, as a consequence of which the arbitrator has a duty to disclose such situations. The green list is a list of situations where no actual conflict of interest exists from an objective point of view, as a result of which the arbitrator has no duty of disclosure. These guidelines were first introduced in the year 2004 and have thereafter been amended after seeing the experience of arbitration worldwide. In part 1 thereof, general standards regarding impartiality, independence, and disclosure are set out. Lordship, it's then set out. And then Lordship will see para 17 from HRD, which is set out. It will be noticed that items 1 to 19 of the 5th schedule are identical with the aforesaid items in the 7th schedule. The only reason that these items also appear in the 5th schedule is for the purposes of disclosure by the arbitrator, as unless the proposed arbitrator discloses his in writing his involvement in terms of items 1 to 34 of the 5th schedule, such disclosure would be lacking, in which case the parties would be put at a disadvantage, as such information is often within the personal knowledge of the arbitrator only. It is for this reason that it appears that items 1 to 9 also appear in the 5th schedule. Now, Lordship, this is an admitted case now. It has been admitted by the Learned Advocate General that no entry in the 5th schedule is attracted in the present case. Neither the 5th schedule nor the 7th schedule, no specific entry is attracted to the present case. Now, Lordship, may I read on quickly? Now, may I come to paragraph 20? However, to accede to Sri Diwan's submission that because the grounds for challenge have been narrowed as aforesaid, we must construe the items in the 5th and 7th schedules in the most expansive manner so that the remotest likelihood of bias gets removed is not an acceptable way of interpreting the schedules. As has been pointed out by us here and above, the items contained in the schedules owe their origin to the IBA guidelines, which are to be construed in the light of the general principles contained therein, that every arbitrator shall be impartial and independent of the parties at the time of accepting his or her appointment. Doubts as to the above are only justifiable if a reasonable third person, having knowledge of the relevant facts and circumstances, would reach the conclusion that there is a likelihood that the arbitrator may be influenced by factors other than the merits of the case in reaching his or her decision. This test requires taking a broad commonsensical approach to the items stated in the 5th and 7th schedule. This approach would therefore require a fair construction of the words used therein, neither tending to enlarge nor restrict them unduly. It is with these prefatory remarks that we proceed to deal with the arguments of both sides in construing the language of the 7th schedule. Now, Lordship, coming back to what was held, then coming to para 31, which is what is held in Chennai Metro. Well, this is to reiterate what Mr. Sarkar just submitted. At this stage, it would be crucial to notice that the court made a differentiation. It stated firstly that a disclosure in writing about circumstances likely to give justifiable doubts is to be made at the stage of appointment, and then stated that the disclosure can be challenged under sections 12.1 to 12.4, read with section 13. The court, however, underlined that in the next category, where the person became ineligible to be appointed as arbitrator, there was no need for a challenge to be laid before the arbitrator. In such circumstances outlined in section 12.5, the party aggrieved could directly approach the court under section 14.1a. It was further underlined that in all cases under section 12.5, there is no challenge procedure to be availed of, and if the arbitrator continues at such, the ground of being unable to perform his functions, since he falls in any of the categories enumerated in the 7th schedule. Lordship, kindly note this is not the 5th schedule, it's the 7th schedule. The party concerned may apply to the court. Now, Lordship, come to para 32. It is therefore evident that the rules for disqualification or ineligibility are fairly clear. The ineligibility which attaches to the appointment is the first category. It is contained in section 12.1, read with the explanation, and the 5th schedule to the Act. As recounted earlier, this schedule has 34 items. In the event any of these circumstances, Lordship kindly notes that these circumstances refer to the 34 items in the 5th schedule. In the event any of these circumstances exist, the appointment of the arbitrator is barred. The second category is where the arbitrator to start with is eligible, but after appointment incurs any or becomes subject to any of the conditions as enumerated in the 5th schedule. In that event, it is open to the party to claim that there could be justifiable doubts about his independence
This
or
is the
impartiality.
case. There.
Lordship, this is the case run by the WPITC. The remedy even then, now Lordship will see even then, that refers to these circumstances referable to the 34 items in the 5th schedule. The remedy even then would be that the party has to seek recourse and apply to the arbitrator in the first stance. By virtue of section 13.2, the wording of section 13.2 clarifies that a party who intends to challenge the arbitrator after becoming aware of certain circumstances which lead to justifiable doubts, that party has to, within 15 days of becoming aware, approach the tribunal and seek a ruling. In the event the party is not successful under section 13.4, the tribunal is duty bound to continue with the proceedings. When the award is made, it can be subjected to challenge under section 34 by operation of section 13.5. Clearly then, the substantive grounds and the procedure applicable in relation to situations where justifiable reasons exist or arise, the questioning the eligibility of a tribunal to decide the reference as enumerated in sections 12 and 13. Now, Lordship, only to place thereafter 33 and 34 quickly. As clarified in HRD, the grounds of ineligibility which would apply at the appointment stage would also continue during the proceedings by virtue of section 12.2. But this continuance is in respect of these circumstances referred to in the 34 items in the 5th schedule, none of which are attracted admittedly in the present case. In other words, if during the continuance of the proceedings, the arbitrator becomes subject to any eligibility condition outlying in the 5th schedule, the application for his removal on the grounds of justifiable doubts about his impartiality and independence can be made. According to the procedure outlined in section 13.2 read with section 12, such a procedure has to first be followed, which means the party should first appear before arbitrator and object to his continuance. In case of ineligibility, which goes to the root of the appointment, and this is the consequence of the introduction of section 12.5, which is in emphatic terms and overrides other previous agreements, the arbitrator's relationship with the parties or counsel, or the subject matter of the dispute, or the existence of any of the categories of the 7th schedule, which are 19 specific enumerated grounds, render the tribunal ineligible to even continue. The only exception is if a party waives that ineligibility expressly in writing in terms of the proviso to section 12.5. This is irrelevant for us. Para 34 thereafter, if I may place. The analysis in HRD Supra and the subsequent decision in Bharat Broadband Supra, therefore, are clear enunciations of law in that any legal disability which attaches on the grounds enumerated in the 5th schedule or any other circumstance, given the terminology of section 12.3, which is not restricted to 5th schedule ineligibility, the aggrieved party has to first apply before the tribunal as a matter of law. In other words, the tribunal should be given the opportunity to deal with the party's reservations and decide whether or not to continue with the proceedings. This view is in accord with the long line of decisions of this court, rendered in the context of reasonable apprehension of bias by courts and quasi-judicial authorities, starting from Maniklal, to raise the issue at the earliest opportunity before the same forum. Malad, may I, with Lord's leave?
Lordship, now, Malad, kindly, Malad, come to later on in the paragraph, I don't want to trouble Lordship with all the cases. Paragraph 43, that's not the ultimate conclusion. The attempt by Chennai Metro to say that the concept of de jure ineligibility because of existence of justifiable doubts about impartiality or independent tribunal on unenumerated grounds, or other grounds than those outlined in statutory ineligibility, so section 5, therefore cannot be sustained. It's very clear. We can hardly conceive of grounds other than those mentioned in the said schedule, occasioning the application in terms of section 12(3). That's my lord, the application, my lord, on the 5th schedule. In case this court were in fact to make an exception to uphold Chennai Metro's plea, the consequence could well be an explosion in the court docket and go on other unforeseen results. Keeping the statutory route carefully divided by Parliament can cast yet more spells of uncertainty on the arbitration process. In other words, the de jure condition is not the key which unlocks the door that bars challenges midstream. Should not to unlock the gates, so and so. From what could petition become case of arbitrator challenge in the court, so and so other. Very clear. It's totally exhaustive. Court is saying I can't even conceive of grounds which is not covered. A bias. And my lord, very advisedly, my lord, did not deal with this paragraph at all. This, my lord, after looking at my lord, voice Alpine and my lord, the other HRD corporation. I'm not citing HRD. I don't want to cite a new case. I've already cited this case. I'm pointing out, my lord, this case lays down. It's very clear. And my lord, this was section 34 situation. Kindly, my lord, look at this. What was dismissed was, kindly see, my lord, section, my lord, 30. Therefore, impugned order is upheld, application so and so, they directed the arbitrator to carry on, my lord, from where they had stopped. So there was a stay. Paragraph 2, lord, you will see. Of the judgment, my lord. There was a section.
Paragraph 2.
Yes.
Yes.
One member tribunal passed away. Tribunal by minutes stated so and so recorded, but party hearing fee so and so. One member tribunal passed away and had to resubstitute it, which was done on so and so. Parties proceeded with conduct arbitration. Meanwhile, another tribunal dealt with 2 claims of AFCON. Award passed, those proceedings so and so. This is the third arbitration was going on. And my suspension, my lord, was paragraph 3. Because my lord, the other proceedings, my lord, section 34 was pending. Tribunal said, I won't proceed with the matter. Now, my lord, voice Alpine and what my learned friend cited, my lord, what was case they have cited. I'm not, my lord, repeating that. 2024 case, core, I think, my lord, central, whatever the name of the case is. My lord, that was the case, my lord, dealing with an appointment of an arbitrator by a party. Lordship knows, my lord, public sector corporation, my lord, had a clause saying managing director will appoint or they appoint from one panel or something like that. That is what came up, my lord, for consideration. And my lord, the Supreme Court said that can't be done after the new act. Now, what Voice Alpine had done, my lord, Voice Alpine had permitted that to happen in some cases. Voice Alpine said that as long as the party, my lord, let's say, my lord, ONGC is a party. As long as the arbitrator is not from ONGC, but from SAIL, then that's perfectly all right. That part, my lord, was negative, my lord, by the Supreme Court judge, Constitution bench. Say, no, that can't be done either. No party can, my lord, appoint an arbitrator of any kind, whether from panel, some other panel, or anyone else. That is not permissible in law. But otherwise, my lord, Voice Alpine was dissented from. The portion which I have cited to your lordship, my lord, saying is exhaustive, not dissented from, and my lord, this has been considered in this case. Lordship, you'll find that here. Now, paragraph to follow, Vice Chairman. Yes, kindly see on item number 1 of the cases cited, page 671. And another point, but I must tell you, lordship, court judgment is judgment. এখানে নেই এখানে থাকতে হবে এটা ওটা ওটা এই বাউন্ড ভলিউম এটা আমরা ওটা সাইড করেছি এইটা এইটা এখানে এখানে Yes. Well, my learned friend cited reference of the 2024 case. Yes, 2024 SCC online, court. It's kindly will not take the end of that judgment. Paragraph, my lord, 169. Oh, Baba. Oh.
এটা না কোর, যেটা এমনি আছে শুরুতেই।
Yes. Paragraph 168. I know the lordship paragraph will tally with mine.
দাও।
168. Paragraph 1. The lordship, my lord,
Wait, sir.
I don't know whether, my lord, our reports are the same.
হ্যাঁ,
I
ওটাই
think they have given, my lord, from Supreme Court website, my lord. My lord, the end of Justice Chandrachud's, Chief Justice Chandrachud's judgment, towards the end of that.
paragraph
But it's para 168 in my copy, my lord, may not be in yours.
168.
Second last paragraph. No, my lord, 3 or 4 paragraphs from the end.
Yes, 168.
So in the present reference, I should start like that. Present reference, we have upheld the decisions of this court in TRF and Perkins, which dealt with situation dealing with sole arbitrators. Thus, TRF and Perkins have held the field for years now. However, we disagreed with Stalpine and court, which dealt with the appointment of 3-member tribunal. So that's why, the only point dissented from was Stalpine. How tribunal will be constituted or not? Then we are aware of the fact that giving retrospective effect to the law laid down in the present case may possibly lead to nullification of innumerable complete and ongoing arbitration proceedings involving 3-member tribunals. This will disturb the commercial bargains entered into by both the government and private entities. Therefore, we hold the law laid down in the present reference will apply prospectively to arbitrary appointment to be made on the date of this judgment. It actually applied only 3-member tribunals. Now, I'm going to see the date of the judgment. November 8, 2024. After the award was passed in this case. What is the way it done? So this judgment has no application here.
That the law laid down in the present reference
That's
will
right.
apply prospectively.
The appointments made after date of this judgment
Appointments to be made
for 3-member
after
tribunals.
the date of this judgment.
And that's on 8th of November.
No, but how will it apply? It is regarding appointment of arbitrator.
It may not, but I'm just saying, since they have cited this to say why Stalpine is overruled. That is not exhaustive. This is the case is nothing to do with that point at all. This is going to do with the appointment from a panel by a party. Even then, it will not apply. It starts up appointment made after 8th November. In any case, it will not apply. So why Stalpine will hold the field? They're saying so. So that's on the point, my lord, of the section 12 being exhaustive or not. If, my lord, it is exhaustive, my lord, no item has been pointed out, my lord. My submission to lordship, my lord, is that at this stage, court should not go into the question of bias at all. It's not necessary, it's not relevant, should not be gone into at all. But I'm not, my lord, answering also the point. But anyway, my lord, since my learned friends, my lord, gave some one-line answers, my lord, to some of the, my lord, matters before your lordship. Yeah. Kindly take my judgment they had cited, that was Justice Manta's judgment. Yeah, my lordship will see that 2023 SCC online Cal 2166 cited by them.
1 second.
They seem to say, my lord, this case decides nothing.
November 2020.
Yes, 2023.
Well, 2023 SCC online Cal 2166 cited by them.
This was cited on 12th November 2024.
Yes.
I only, my lord, pointed out one paragraph.
Yes, tell me paragraph number.
Paragraph 69. My lord, they have referred to paragraph 70.
Amado. Thank you.
Paragraph 69, Milord. See what I have relied on. Now, in this case, what happened, Milord, was the arbitrator was appearing for one of the parties during the pendency of the arbitration. And that matter, after the award was passed, was challenged. It was set aside. But I'm on paragraph 69. This court is, however, not inclined to accept. I'm relying on this line. Paragraph 69, Milord.
One second. Yes.
The court is not, however, not inclined to accept the non-disclosure of the arbitrator having represented SS so-and-so in the High Court, pendency of arbitration would amount to fraud. Appearance in a matter for a party is also not fraud. Now, they want to show, they want admittedly so-and-so, that much, then see 70. They rely on this. Kohli has candidly submitted in the course of his argument, the client would not wish to press the argument of corruption and fraud bias against the arbitrator, which of fraud not dealt with. But, my lord, the paragraph 69, the first line remains as a finding of the court. Mr. Kohli, my lord, may later on say, my lord, it's my lord, very common for us, counsel, my lord, the judge is not, my lord, going my way, my lord, to say, all right, I'm not pressing that part. All of us do it. It's part of the tricks of the trade. So, but the judge's finding is clear, para 69, I rely on this. It's a coordinate bench judgment by this court. Appearance by a party, not, my lord, going and, my lord, launching some electric car. Can't be, my lord, higher than that. Pressing or not pressing, my lord, makes little difference. Now, my lord, the other, my lord, point is, lordship takes a lordship judgment. My lord, kindly say the judgment which your lordship has been pleased to pass.
No. Copy.
Give a copy. Please. Now, my lord, this judgment shows first that, my lord, the argument of the petitioner, my lord, is that without impleading the arbitrator against whom allegation is made, the question of bias, my lord, should not be gone into. That's why they made this application. After, my lord, we had cited some arguments, cited some cases. That is, my lord, the argument advanced before, and that is, my lord, recorded by lordship. Now, lordship will see the finding which the lordship has given. That's, my lord, paragraph 23. Paragraph 22, my lord, lordship has laid down what the prima facie fraud and corruption is required. Then, my paragraph 23, my lord, lordship mentioned, noted that all cases cited by them are section 34 cases. That 36 doesn't arise. Then, my lord, 23. By filing the instant application, the award debtor prays for impediment of the concerned member of the tribunal, even before the adjudication of pending section 32 application. Unless this court arrives at primary finding of fraud or corruption, even bias as alleged so-and-so, fact is question of impediment so doesn't arise, finally can't be placed. Now, I submit to lordship, question of bias doesn't arise in law. And that's what the lordship has said. That, my lord, 36(2), you recite prima facie fraud or corruption. If lordship, my lord, feels that my bias can be gone into in this application, then lordship have to give, my lord, notice.
Yes, so unless this court arrives at a prima facie finding
That's
of
right.
fraud or corruption.
So, my lord, prima facie means what, my lord? Lordship feels that something needs to be gone into. But I am, my lord, submitting, my lord, fact, in fact and in law. Lordship should not go into this matter, need not be gone into. In fact, my lord, lordship does that and comes to a finding, it will be prejudging something taking place, my lord, in section 34 stage.
No. The language, forget the expression bias for the time being. the language under 36(2) to deposit or not to deposit is the court has to come to a prima facie finding with regard to fraud or corruption.
Something more, my lord. Kindly take the section. Something more, for which I'll, my lord, give.
কোথায় গেল? ওইটা কোথায়?
Well, I won't repeat any of the cases I've cited already. I just, my lord, name them. He just got a copy of the act, my lord.
Yes, yes, just now I have seen. কোথায় গেল? Yes. হ্যাঁ,
বলে দাও, কবে করে বলে দাও।
yes,
Second proviso, my lord. Provided further, that you got it?
once, yes,
When the court is satisfied, prima facie case is made out, the arbitrator so and so, the word, was induced or affected by fraud or corruption. Kindly, my lord, not lose sight of the words induced or affected. Induced, my lord, or affected. But it was a party-generated fraud, not something in the air. That is important. That the party or the parties have generated something.
but they say, again, first, leave aside for the time being the expression bias. What they say, that one of the parties to the reference whose program has been attended.
No, not our program. The dealer's program.
Dealer's program.
Not a respondent's program.
Right.
That's very
Dealer's,
important.
yes, dealer's program.
That's all.
So they try to create a nexus, or they try to establish a nexus in that way.
So that then, but when Lordship tomorrow has to come to that finding
Finding
of inducement,
prima facie,
of inducement, my lord, is important. Not just, my lord, saying something is fraudulent or something is biased. Inducement of fraud, even if bias is fraud. Let me, my lord, leave that question aside. My lord, my learned friends have referred to some Bombay judgments. I told Lordship, why, my lord, the Bombay judgments have come. Well, this amendment came in 2021, but it was introduced with effect, in retrospective effect from 2015. Bombay judgment, my lord, a division judgment of Bombay is 2018, before, my lord, the amendment was introduced. Where, my lord, some stay was granted. All subsequent single bench judgments of the Bombay High Court, without considering, my lord, second proviso, should the judgment, I'm not repeating, my lord, the argument, has followed the division bench judgment. That's what they have referred to in the last occasion. My learned friend mentioned it. They did not, my lord, deal with our Calcutta judgments, my lord, which were given under 36(2). I've given you, Lordship, I think 3 judgments, if not 4. Yes. And, my lord, the case we have cited, Essex, when my learned friends, my lord, WBIDC is also a party, deal with all these judgments. That is, my lord, reported in 2024, SCC Online Cal 6791, cited on 5th of March 2025.
2024 SCC Online.
Cal 6791. Cited on 5th of March 2025.
ঠিক আছে।
I'm not repeating that, my lord. I've given that to your lordship. The other judgments are referred to there, but the other judgment reference also I'll give you, lordship. It's all noted. All judgments are all noted here. They're not dealt with. But they are a coordinate bench judgment by your lordship. The lordship has to follow in the normal course. What is the point, my lord, in going west to Bombay? For any reason. And Bombay does not consider none of the judgments, my lord, Bombay consider the proviso. Lordship will examine that. I am on an argument on the proviso here. Not considered by Bombay. Considered, my lord, by several Calcutta judgments, including last one is 2024, I given your lordship. Where, my lord, the contours have laid down. Must be an inducement of some kind of fraud.
Another submission they made under Order 41, that still a discretion is there with the court to waive.
Well, it's all, my lord, kindly take this judgment. Didn't you? All dealt with here.
Which one?
The 2024 Calcutta judgment. Can you show that? I want to cite new cases. I don't want to cite new cases. It's all dealt with, Lord. Supreme Court has dealt with it. Supreme Court has said, it's a legal fiction. CPC doesn't apply.
2024.
STC online Cal 6791.
5th March সাইট করেছিলেন
2013 এ case
না 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 এটাও নাও
whatever cases they have cited are pre-2015 amendments. B-25, I'm told
এইটা এখানে লাগিয়ে দাও
26 of Ghazal Tanaya. My Malay juniors are very hardworking. 2013 7 SCC 543. They cited a case. Before 2015 amendment, no case is relevant. There was no provision for stay under the Arbitration Act. There's automatic stay in those days. Filing of
automatic stay.
Yes, these cases are not relevant at all.
It's not an arbitration case, it's a civil suit.
And that was civil suit. A civil suit. Relevant paragraph to follow, bhai.
Pre-2021 amendment.
Yes.
Pre-2021 amendment.
44 to 58. This is referred to submission of parties, including the Bombay judgment.
Case below situation.
All the cases are extractable.
Ghazal Tanaya was.
44 to 58. Right.
My lord, kindly come to paragraph 44. From 44, my lord, to paragraph
This
58.
Calcutta judgment 2089.
No, 6791. The Calcutta judgment, my lord, actually given your lordship, my lord, 2024 STC online.
Yes, 678 now
91.
ওটা কোথায় ওইটা দাও
6791.
But that is government of West Bengal and another versus
Essex
development investments
Essex 6791
was cited on the 5th of March.
page 5th of March পেয়েছি কিন্তু 6791 page. Yes.
Well, from paragraph 44 onwards, my lord, the entire law is considered. Including my lord, Ghazal Tanaya's case. In paragraph 46. Including Bombay case, paragraph 45. And my lord, your lordship point of civil procedure code, come my lord to paragraph 47, what the Supreme Court has said. Paragraph 47, my lord, PAM development, Supreme Court case, my lord, is quoted. The CPC doesn't apply. Logic quotation amal, PAN development, paragraph 20 of the judgment, lordship will see, having regard to, which construed having regard to in the Arbitration Act. At the bottom of the page, in our view, in the present context, phrase is used having regard to provision of CPC, not in accordance with the provision of CPC. In that case, would have been mandatory, but in the form as mentioned, 33 of Arbitration Act, directly not a guiding factor.
That's a guideline.
May I refer? That's right.
That's right. I in fact, last day I said to Mr. the learned Advocate General that Order 41 is merely a guideline, nothing more than.
In this case, Lordship will find, my lord, the Calcutta case is paragraph 48. Earlier Calcutta case have been considered, and my lord, 100% deposit was directed.
Yes.
100% deposit. Kindly see the end, including interest.
Today the law in respect of 36(2) is the awarded amount with interest,
That's right, 100%,
the deposit.
including
with-
cost.
in-
Yeah, even cost was deposited, directed to be deposited. It's not been done, that's another matter.
Including interest.
Paragraph 57.
Yes.
Lordship will see, my lord. Entire awarded amount, register original site per period 6 weeks from date, the awarded amount shall transfer to bank in account register so-and-so, so-and-so invest in interest bearing fixed amount, national, remaining 50% awarded amount within a bank guarantee, in the time period award so-and-so shall be stayed from the pending. Not been done, my lord. So anyway, that's neither here nor there.
Petitioner are directed to secure the entire awarded amount with the registrar, original site within a period of 6 weeks from date. 50% of the awarded amount shall be transferred through bank in the account of the registrar, and the registrar shall invest in the interest bearing fixed deposit account, and remaining 50% awarded amount by way of bank guarantee.
50% cash, 50% bank guarantee. The entire amount was secured. That's your also discussion, my lord. Or, my lord, my contention, my lord, is 100% deposited. Secured, my lord, is my submission.
SLP from this dismissed, review petition before Supreme Court also dismissed.
My SLP was dismissed, my lord, from this judgment. Review was filed, also dismissed. This judgment holds the field.
Give me the SLP order.
The SLP order. What's yours? Review. No, actually. Yes. Review touch Canada.
Acha.
I think we have given it.
It is there. Placed on the same day, 5th
Yes.
of March.
Fine. No, my lord, I've given the Supreme Court order in this matter. My lord, it's a one-line order. So, my lord, the order your lordship wanted in this matter. The one-line order, my lord, Supreme Court order, my lord.
Yes.
One line, no. In this matter, in this.
Yes, you have it.
My learned friend, I cited up some observations. My learned friend were there. They know what was happening. Not I'm not getting into that. But my lord, the order is clear. It's been dismissed. Well, my juniors are keen to say what the Supreme Court said, but I will lordship has already heard that, so I don't.
No, what is not there on the
Yeah,
order
exactly.
is not there on the order. Newspaper reporting.
Newspaper report আছে? ওই petition নাকি? Petition? এটা petition report? Oh, আমি জানি না। I'm told you report in newspaper, I don't know. I don't read these newspaper reportings. ঠিক আছে? But I have not cited any new case. No? That's why when the HRD I did not cite, only pointed out more HRD from what the case already cited.
When you are filing your note.
I've got my note, my if lordship, I don't know if they want to file today, I can do it, or my lord, they want to add or modify something.
One thing that I need to deal, only one line, I'll summarize in one line. One submission has been made today is whatever I have argued are all to be looked into at the 34th stage. Only on that point where I
just not today.
No, I'll not argue anything. I'll put it in my notes. I'll put it in my.
You have assured this court you will file a
I
note
have,
on this.
but on
Malad,
this
Malad.
matter at least I'll put in.
No,
my
no,
note.
Malad, may I beg you, this is Malad, it's happened once before, Malad, in this matter. They will Malad, start my YouTube, Malad, recording about what I said. Let me, Malad, make it
No,
very clear. Let
we
me
are
make it
making-
very clear, Malad. I'm only saying, Malad, that it may be gone into. I told your Lordship, at that stage, I may object to it being gone into, but it's not relevant now. I could not say, if at all it's relevant, Malad, it has to be gone into 34, not now. Doesn't
Listen,
mean, Malad,
this
I,
point I- this
Your
point I
submission
agree.
is if at all, then at the
At
30.
it's not a
34.
concession that it can be taken at 34. My submission of waiver will remain. Lordship, you can go into that, I don't mind. Fact of waiver, my lord, Lordship, posing that question of bias, kindly, my lord, deal with the argument of waiver. The 15-day period passes, my lord, you can't take it anymore. I've argued that point, I won't repeat it.
No, that you have submitted.
That is taken in my report,
That's
in
it.
my written
Correct,
notes.
correct.
Right.
That's all.
That of course.
And
I-
you
remains.
said that even if they take this point, even if, then 34 stage.
Right.
If at all. But it's not,
Even
if it's not
if
a
at all.
concession. Let me make it clear. It's not a concession that it can be done.
No.
Because there I'll object. I'm telling you now, my lord, I'm telling him now. I'll object that it can be taken up at 34. When he raises point of 34 comes up, it can't be done because it's smaller of the 15-day rule.
No, it cannot be that I cannot take it in the 36 stage. Then when I take it at the 34 stage,
It's a legal
please have
argument.
a consideration.
Give me your note.
Only this way I'll include in it.
My learned friend files now, we'll file it now. I'm ready with my note. I told you, Lordship, I'll be ready, I'm ready. Let us, Malad, file it and close it.
It's here, Millard. I'll just add, Millard, 1 or 2 paragraphs and then give it to you. Just have a look at it.
Why should I?
Then permit
কেন
you to.
খাটবো আমি আবার?
No, just have a look that it is ready.
There has to be a disclosure in that case.
Yes. But I had not made any admission. This is also a very important thing. Where have
What
I made the admission? That bias is not in the Schedule 5 or Schedule 7.
But he's not pointing
What I
out.
am
This is submission.
yes, my argument is that bias is so basic disqualification.
It is included
In
within
it,
the meaning
yes.
of fraud.
Yes.
Within the meaning
Well,
of
all we
fraud.
said was none of the items have been identified as not covered in this
Yes,
case.
yes,
Not bias in general.
Not identified.
That's right.
It's so
This
basic.
case, Malad, not general bias. We're not concerned about general bias. Malad, opening of electric vehicle cars, where is it featured in 5th schedule? That's all.
So
There is
today
not
we
a-
are on Thursday. I'll file it on Monday. I'll hand it up to your Lordship's officers.
No, it's an assigned matter, so I'm keeping it in the list.
Where we'll keep it as to be mentioned only for file.
No, on the original side list, I will keep it. Because it's an assigned
Monday to
matter.
Friday,
So
Tuesday.
in any event, it's like personal law. Wherever I will go, it will go.
Yes.
Covenant running with the land.
Covenant running with the land.
But if my learned friend doesn't file today, Malad, matter will go into a spin. I can assure my learned friend. Let him file it. We'll file it, Malad. Let's close it. Said what he wanted to say. Lordship heard us.
It on Monday or Tuesday, whichever day, we'll just for, as to be mentioned for filing.
Monday, Tuesday, আমার কোনো
সব নামগুলো দিয়ে দেবেন দেখে দেখে, কারণ এটা না দেখে দেখে দিতে হবে, ভুল না হয়।
কিছু না।
মিস্টার সুদীপ্ত সরকার, learned senior advocate, with Mr. Siddhartha Mitra, learned senior advocate, appearing for the award holder, has concluded his submissions.
On section 36.
হ্যাঁ, on section 36 within bracket 2 application. Section 36(2) application. Full stop. Learned Advocate General for the state. Prays for some time.
I'm sorry.
No, please listen. That's fine. Learned Advocate General for the state prays for some time to file written notes.
State no and WBIDC.
WBIDs.
No, Learned Advocate General for the state appearing for the award
I see,
data
I see, I see.
prays for some time to file written notes. Paragraph, Mr. Sharkar submits that the written notes on behalf of his client is lying ready with them.
We will file it simultaneously.
They shall also file on the next day. Paragraph. By consent of the parties, the matter shall appear once again under the heading application bracket is specially assigned marked at 2 p.m. on Aji ko tarikh. August 28, 2025.
That's Thursday.
August 28, 2025. When the parties shall file their respective written notes.
My lord, we have not given any of the judgments here. Lordship has your own copy marked, I think. So it's thought not better we don't give. We only refer to the judgments. That's all.
Refer?
With the copy, no, note, my lord, is not very long because judgments are not here.
No, but you have referred
Yes,
to
yes. But I'm not
You have
giving
not
the
annexed the
no,
judgments.
or
Not
quoted,
required. Required.
It will becoming quite.
We have
bulky.
quoted the relevant paragraph.
But becoming quite bulky, my lord, so we have refrained from.
All right. But if you wish, you can give
No,
by spiral binding.
But as your file, you lordship has marked everything. Why should you not give it? See, everything is here. No, nothing new here.
এটাও রেখে দাও। Thank
Grateful.
you. Thank
I'm
you.
good. কত আছে?
The difficulty is, I tell you, time constraint because first 2 weeks I'll not be here in September.
I see.
Circuit.
Anyway, this is over now for the time.
That's the time constraint.
You overcome that time.
Otherwise, I could have.
That is
Otherwise, I could have done some work, my homework.
Lordship has noted down everything, but in any case.
Otherwise, I could have done my homework during this
No,
period.
lordship has your lordship notes any case, my lord. This is only it will only my lord, assist your lordship. That's all.
So
Taken down.
that's the difficulty.
Notes.
intensive classwork, not required.
And the papers are so voluminous, I don't wish to carry.
No, not.
Oh, holo.
That is why we have
ওতে আছে আমার নেই নাকি?
Get used to this. I carry my entire chamber with me.
No, he's young. I'm old, my lord. I don't even know what that is.
Older people have.
I can't even
carry your
operate.
entire chamber. Then
I
people
can't
are
even
coming.
operate that.
You cannot carry
I
heavy.
have no chamber to carry. Anyway, that all that is now gone, moral history.
You cannot carry.
Thank you.
Delhi for here.
My chamber is too old, my lord. I can't carry.
It's too big.
Old and big.
When I joined, he was not too old, neither was I old. Now with years,
You are becoming old. He is not.
he is young at heart. I am old. I don't mind. I'm old. So if I'm old, I'm old. What's
Yes.
there in it? Item number 2. I'm not Mr. Siddharth Sethi, who is becoming younger by the day.
Well, on the last occasion, I had indicated that I have virtually finished. If anything is required, 5 minutes I'll take today. I'll finish within 5 minutes.
Then they will have to reply.
No, Mr. Kaur is appearing for
The rest of the respondents.
rest of the respondents.
Kolkata Municipal Corporation.
Acha, no, Mr. Alok Kumar Ghosh is
Mr.
there.
Alok Kumar Ghosh is there. Above him, he has been.
I don't. That is all right.
But,
No, if Mr. Kaur is not there, Mr. Advocate,
Yes, sir.
then I'm sure his junior is here to argue. Mr. Kaur is not there. If Mr. Kaur is not there, his junior will carry out.
Whatever the court desires, that will be carried out. এই আছে তো কাগজপত্র তৈরি কর Nonetheless, one of the sheet anchor of Mr. Mukherjee's argument or case was that the jurisdictional facts was not stated in the notice. But I had submitted to your lordships that Miller, the jurisdictional facts are not required, that this submission is over. But assuming that it is required, then also, but I would be very respectfully submitting that this has also been complied with. Why?
29 July, last argument.
Right.
And you argued on lastly on that day, alternative remedy, appellate authority is there. Then, so you relied upon 2022-17 SCC.
Right. Yes, ma'am.
Then you argued jurisdictional facts not stated is not correct.
Yes.
Then you said report under section 4 has not been provided.
Right.
That is the submission of Mr. Mukherjee. Acha. Then you said the non-mentioning of jurisdictional fact relating to satisfaction of Rule 2G and 3 of the Act and the alleged non-supply of reports under Section 4 are not valid reasons cited by the petitioner for entertaining writ petition, bypassing appellate remedy. Then you submitted disputed question of title based on injunction, blah, 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 not to be gone into in writ court. 2024 6 SCC.
Only to complete. Please come to the section once more, Millard, which is annexed to the writ petition. Section 4 is at page 86, volume 1.
স্টিকার করা আছে দেখো অ্যাক্ট বলে স্টিকার করা আছে আইয়ে কত তারিখ 21/8 Yes. Act.
Look at page 86, section 4, subsection 1. It's a very long subsection. Please come towards the middle of that subsection. Whenever the competent authority, where a sentence starting with whenever. Whenever the competent authority on any report or on the receipt of an information from any source or on his own motion, well, our case is own motion case, is satisfied that the provisions of this act applies to any property lying within the state, he shall cause an inquiry to be made as to whether the fact or facts as stated in clause G of section 2 as would attract the provisions, attract the opposition of section 3 of this act exists or exist, and on his being satisfied on such inquiry that such fact exists, he shall pass an order accordingly recording that such fact exists, on which the order recording the existence so and so. Therefore, what is to be stated is as to whether the facts constituting clause 2, section 2 clause G, which would attract the provisions of section 3, whether that is required to be stated. Number one, since this is a suo motu or a Own motion case, no question of any report.
Right.
And number 2 is the jurisdictional facts is what, if at all, required. Is that
Compliance with 2G.
now please take note page 82.
Page 82.
82 of the writ petition. It starts at page 80. But this is a subsequent notice, Millard, after the Supreme Court's direction.
'81.
But it starts at, I'm so sorry, 81. I'm so sorry. It's at starts from 81. Kindly take, Millard, this
2nd April.
Yes, 2nd April. Please take the next page, page number 82, where there is a schedule at page 82. But after the schedule, the recital and whereas the competent authority therefore desires to cause an inquiry to be made as to whether the fact or facts as stated in clause G of section 2 as would attract the operation of section 3 of the said act exist or exist in respect of the aforesaid lands. Therefore, Millard, whatever is the statutory requirement, where that has been met, where, Millard, we have said that you are or we are making an inquiry as to whether 2G or the facts stated in 2G exist or not. Sufficiently made known. Therefore, Millard, this is compliance with whatever is required under section 4.1 or part of the section 4.1. This is one thing, Millard, I need to, Millard, highlight. The second and the last thing that I need to highlight is but as your Lordship would be recollecting, that this is a second round. Identical notice minus the schedule was given to them, which ultimately reached to Supreme Court. Supreme Court relegated the matter before the authorities for a fresh consideration. Now, please have a look to the order of the Honorable Supreme Court, where it starts at page 75. On this aspect, please take, Millard, section page 78. But at the top, only on the ground that the show cause notice is defective, we set aside the order dated 29 January. It is obvious that the state government is not disputing the title in respect of so and so. Therefore, a fresh notice can be issued for the remaining area. Therefore, the order of the division bench is set aside. After a fresh notice is served, the appellant will file a reply so and so, thereafter an adjudication so and so. If any adverse order is made, it is to be decided. No, so I'm so sorry, I missed that. It is the previous page. I'm so sorry. I'm so sorry, Miller. Kindly take me at page number 77, last paragraph. I'm so sorry. Page 77, the last paragraph. Therefore, it will be appropriate if the first respondent is permitted to issue a proper show cause notice clearly describing the property in respect of which STT is claimed by the government under the 2012 Act. It will be also necessary that the state annexes a proper sketch of the property in respect of which the claim is made. That's all. That was the only defect. Rest where it's all right. Therefore, what the Supreme Court required was a sketch and a schedule. The sketch and the schedule was given. Therefore, the jurisdictional facts not known to them, not understood, not disclosed.
These are all taken care of by the Supreme Court, and then after considering those, according to you, the Supreme Court had made
Only
these two
limited it
paragraphs.
to this part. But these are the only two things where I intended to highlight today. But these are my submissions.
So where is Mr. Kaur?
Hey, yes, sir. Oh.
Mr. Kaur would be available there. Tuesday, Lordship. I had a discussion with him. He will be
No, you assured on the last day
He was
that you will continue.
would have
You assured, sir, that you will continue.
he will start on Tuesday. That is what he has said. He will make his submissions. He will make his submissions on Tuesday, Lordship. Lordship,
You committed, sir, that you will continue.
Lordship, only with that respect of the matter wherein the learned advocate general has not, to that respect, Mr. Kaur will make his submissions, Lordship. So that was,
Mr. Learned Advocate General has concluded.
yes, Lordship.
So you start.
What is the leader, Lordship? Kindly allows Mr. Kaur to submit.
I will allow him, no issues, but you also start. When?
Tuesday, Lordship. Tuesday.
মিস্টার কিশোর দত্ত আচ্ছা কে কার হয়ে অ্যাপিয়ার করছে এখান থেকে দেখে নেবেন মিস্টার কিশোর দত্ত লার্নেড অ্যাডভোকেট জেনারেল has concluded his submissions. Appearing for respondent numbers 1. What is your name, sir?
Arindam
Mondal.
Mr. Arindam Mondal, learned advocate, led by Mr. Joydeep Kaur, learned senior advocate, prays for an accommodation on the plea that on the next day, Mr. Kaur shall commence his submissions. On behalf of respondent number?
The Judicial Department, Lordship.
2. Mr. Banerjee. Mr. Shobhan Kumar Devnath, with led by Mr. Alok Ghosh, learned advocate, and Mr. Ochinto Banerjee, learned advocate, appearing for KMC, shall make their submissions after Mr. Kaur completes.
So next day our turn won't come. We shall give a rejoinder the day after that.
Mathar upor Mr. Obhrojit Mitro, learned senior advocate, appears for petitioner.
I'm deeply obliged.
No, next 28th I will keep.
28th, Your Lordship.
28th.
28th is a difficult, Your Lordship. Kindly excuse on 20. 26th is fine, Your Lordship, kindly.
বুঝো আমার অসুবিধা থাকতে নেই
Mr. Kaur would also be available on 26th. Your Lordship.
Can't be only one day.
Yes.
Can't be only one day is available.
Yes.
28th, no. 28th. Gotcha should be there. Mr. Jadiba won't be here.
I may not be here. Mr.
No.
My senior may be here, but I will not be here.
Oh.
From 28th, Your Lordship.
From first, for 15 days, this court will not be there. Come after what to do.
Your Lordship, I'll try. Please mix it on 28th. I'll try. I'll try.
August 28, 2025. Under the heading court application. Because in any event, what I find, Mr. Mitro, Mr. Sen, that
Will spill over.
it will in any event.
So our rejoinder will
other
be
side,
after that.
after the, because Mr. Kaur will submit, he shall conclude, then the corporation, they shall conclude, then your turn for rejoinder.
Your Lordship, kindly excuse my absence on 28th if in the event I am not there. There is a high probability. Your Lordship.
Next Tuesday, Mr. Mohammed, I will tell your Lordship, as per the convenience.
Oh, Lambda.
আজ ডেট ফিক্স করেছে আবার কি বকবো তো অলোক ঘোষ বলে দিতে অলোক ঘোষ বলে দিতে একদিন দেখে দিন অলোক ঘোষ বলবে
The corporation may
Do whatever you want.
What do I say?
Number 3.
Yeah, for the
This matter, my lord. This is my exception to the report, my lord.
What is the matter?
Matter relates to, my lord, the compassionate employment of the listener, my lord. Here, the father was an employee, died in 1998. Thereafter, my lord, the application was made for employment. Now the petitioner is aged about 50 years. Now, if you lordships kindly come, page 18.
You have filed exception,
Yes, yes, just now I have given, my lord.
but it is not there. Oh, you just now.
Just now I have given, my lord. Because matter was, my lord, second time is being taken.
Care of Mr. Partho Ghosh, learned advocate, appearing for the petitioner. Din Utadin, time to file exception stands extended till today.
No, in time, my lord, I have.
Comma, the extension filed in court today is taken on record.
It was affirmed in time since the matter is being taken up, my lord.
Proceed.
Yes, my lord.
Time to file, I say.
Yes, yes, my lord.
As per the appellate side rules.
My lord, if you lordships kindly see page 18,
The report is already on record.
my lord. Page 18, if you lordships kindly
What is
See.
the rejection plea? Plea for rejection?
claim for, my lord, compassionate employment.
No. Why they have rejected?
Actually, my lord, they have not practically rejected. They have processed and kept the matter pending since 1998.
When you applied, when the death occurred,
That's why, my lord, I wanted to show page.
7th of November 1998.
No, I believe.
No.
Page 18, my lord. This is the death certificate.
date on
7th November 1998.
death. Application,
So immediately I made application, but the copy,
date.
my lord, a copy is not with me, my lord. Copy is not traceable. I will satisfy to your lordships from their document, page 23, my lord. In 2014, they asked the petitioner for medical examination. Serial number 1,
Page,
page 23,
writ petition.
my lord. There are 9 applicants of the another deceased. Now petitioner is serial number 1. In 2014,
This is not their document, it is your document.
no,
Show me
issued,
their document.
no, issued by the assistant manager Kajoda area. This is their document.
Page 23.
23, my lord.
I'm looking at 23A.
No, 23A,
Is the same.
23A আছে নাকি আবার?
I do not have any document.
My
for
23, my lord.
I do not have any document in my.
But kindly see the issued by assistant manager
Turimunda.
Turimunda.
Oh, this is report. I'm sorry. My mistake. Yes,
Page 23, my lord.
you are requested to kindly direct.
As the case of the following deceased employee have been screened by the area screening committee, Kajoda area, you are requested to kindly arrange for medical examinations of the following dependents of the deceased employee of the medical examination board.
Where is your name?
Number 1, Turimunda.
Very well.
Now, thereafter, my lord.
Thereafter, what has done? What
My lord,
they have done?
page 24. This is before that. This is a document of 2010 at serial number 12. Kindly see, my lord. This is the status of employment under NCW up to March-November 2010. Here, my lord, there is a system under the Eastern Coalfield, my lord. They publish the, my lord, name of the persons, those who are being processed in their, my lord, website. I downloaded from their website in way back, my lord. Now, kindly see, it has been processed up to 2010. Turimunda, son.
Which page?
Page 24.
Yes.
Serial number 12. AD number 0058. This is the file number. They send, actually, my lord, thing is, my lord.
Serial number?
12.
Sadhan Munda.
Sadhan Munda, father's name. At, my lord.
Oh, Turimunda.
Turimunda's son. Thereafter, kindly come the remarks portion.
Son.
Son. Thereafter, kindly come return to area
for
compliance. There may be some shortage of document or something else, so they have returned the file. Now, thereafter, again the file was sent before the headquarters after observing all formalities. That is at page 25. Status of employment under National Coal Wage Agreement up to August 2023. Page 25.
25.
My lord.
Status of.
At heading, my lord, status of employment under National Coal Wage Agreement, August 2023.
Acha.
Next page, my name is at serial, my lord. ED number the same, ED number 0085. You also will find, my lord, Sadhan Munda.
Yes.
Munda. Again, return to area for compliance. Page 26.
Serial number?
There is no serial number. You will also find 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 from top.
Munda.
Yes, ED number 0085. Again, return area for compliance.
Yes.
Thereafter, my lord, I made RTI as to why my case has been kept pending in spite of several, my lord, documents and in spite of, my lord, observing all formalities. Now, my lord, I have annexed all documents of RTI, and finally I made application for employment as well as monetary compensation, but they have not neither paid nor provided employment. Since 1998, my lord, I am suffering. Now the petitioner aged about 50 years. At the time of
So
death.
Don't go for employment. Go for MMCC.
From the date of death.
What is the law?
Yeah.
Let me.
Now, my lord, they will say that the monetary compensation is not applicable to the female. It is fact. Monetary compensation is applicable.
This is not a fit case for compassionate appointment after 20 years.
No, they have consumed the time. This is their fault.
It's their fault.
Now,
Sue them for damages, but This is not the case for compassionate appointment.
Allow me to place two judgments.
Keeping in view Umesh Nagpal.
Yes.
You carry Umesh Nagpal?
Umesh Nagpal I do not carry, but following the Umesh Nagpal, there are several judgments which I will, even the recent judgments, will cite. And citation the bolo.
2018 volume 11 SCC page 201.
2018 11 SCC
201.
20.
Subhotra. I know that Subhotra.
Now, if your lordships kindly come, this judgment, my lord, relates to the same scheme of National Coal Wage Agreement. Now, paragraph 5, if I may allow to read, my lord. The Learned Council for the respondent organization has invited our attention to the decision of this court in Canara Bank versus M. Mohesh Kumar and submitted that the compensation appointment is not a matter of right. And there is a discretion available to the employer. We have no quarrel with the settled position, but the instant case is not a case of discretionary compensation appointment governed by very statutory guidelines. It is governed by a scheme as agreed by us, as agreed by the parties.
Paragraph.
I'm reading from paragraph 5, my lord.
5.
Supreme Court has decided the same scheme, my lord.
Yes, read
The
on.
Learned Council for the organization has invited our attention to the decision of this court in Canara Bank versus M. Mohesh Kumar and submitted that the compensation appointment is not a matter of right. And there is a discretion available to the employer. We have no quarrel with the settled position, but the instant case is not a case of discretionary compensation appointment governed by any statutory guidelines. It is governed by the scheme as agreed by the parties and which has become a part of the bipartite agreement. The terms of the agreement are very specific and give no room for any discretion. In para number such and such of the agreement, it is clearly and specifically mentioned that the female dependent, if below 45 years of age, has an option either to accept the monetary compensation or employment. It is not an option reserved to the employer, but an option given to the employee. It was a terms of the agreement only that the appellant had insisting that she should be given employment. Here the case of the female, if she is otherwise eligible in terms of the bipartite agreement. But the second respondent kept on insisting that the son being the above age of 12 years would be kept on live roster until the age of 18 years, and till such time the appellant would be given compensation 3,000 in terms such and such. Para such and such would come into play only in a case of para such and such does not operate. Employment is assured to the dependent in terms of the bipartite agreement. If the female dependent opt for employment, there is no further discretion left to the employer unless he is otherwise ineligible. There is no such contention raised by anybody. In the facts and circumstances of the case, we have no option but to set aside the judgment of the High Court and dispose of the appeal in proper perspective of the bipartite agreement. The Learned Council for the respondent point out that the employment to the appellant at this stage and age may not be workable relief, since the appellant herself has later requested for employment to her son. But the question as to how to compensate the appellant for a period of 2004 to 2018, having regard to the entire facts and circumstances of the case, we are of the view that the interest of justice would be met and complete justice to the appellant will be rendered in a case of appeal is disposed of as follows. The second respondent is directed to appoint one son of the appellant who has otherwise become major as of now, as per the choice of the appellant within 2 months from today. Needless to say that the appellant will be commensurate, the appointment will be commensurate with his qualification and entitlement of the incumbent. From 2004, as ordered by the High Court, the appellant shall be paid 3,000 rupees per month, along with the interest at the rate of rupees 7.5% from the respective date when the amount become due. Towards all other claims on account of loss of employment for the last 13 years, as far as the appellant is concerned, it would be just and fair, reasonable that a lump sum amount is paid to the appellant, which is fixed as 5 lakh. This amount shall be paid to the appellant within 2 months from today.
Paragraph 10 makes the judgment not a binding effect.
But the earlier paragraphs, paragraph 10 is not binding.
The ratio, the ultimate finding is not binding. It's a 142 case.
But the earlier paragraphs, there is no discretion left open to them.
Maybe those are discussions.
Now, my lord, another judgment of this honorable court
This is
reported
not a rule of law.
reported in 2024 SCC Online Calcutta 7361 page number.
2024 SCC Online.
SCC Online Calcutta page 7361. This is a very recent judgment, division bench judgment of this honorable court. Sukumani Hemrom versus Union of India and others. All these judgments, delay point, everything has been discussed by the division bench. Now, my lord.
On the same scheme.
Same scheme, Eastern Coalfield. All these judgments, Putul Ravidas, Kumari Kiran Singh, Subodra, this judgment, just now I have shown to your lordships. Everything has been considered. And finally, my lord, if your lordships kindly come, the last paragraph, last page, page 45, paragraph 45. There is a special bench judgment of this honorable court. And the special bench also hold in a case of compulsory employment in a Eastern Coalfield Limited, it is a matter of right. Paragraph 45, if your lordships kindly come.
Paragraph
45.
No, that I have also held right in Bauri. But
it's in respect of
when? After 30 years.
Well, page 45, because they have caused delay.
Paragraph?
Paragraph 45. Because they have caused delay. Up to 2023, they processed. They never communicated that your claim is rejected.
98 to 14, nothing.
There is a document. Otherwise, they would not have conducted the medical examination.
All right. But 98
and they
to
never
14,
rejected on the ground of delay or a because I have waited in even 2023, they processed.
Yes, yes. But now today, compassionate appointment is not.
Paragraph 45, if you also kindly come.
Yes.
Unlike other scheme for compassionate appointment, which usually provides for negation of claim of appointment on the grounds of financial solvency or delay, clause 9.3.0 to 9.5.0, this is the same clause of the National Coal Wage Agreement does not specify financial solvency or delay to be disqualification for receipt of compassionate employment or monetary compensation. As noted above, provisions of NCWA, which is settlement within the meaning of such and such, as required to be strictly construed. Thereafter, Putul Ravidas judgment has been referred to special bench judgment, has noted the Putul Ravidas Supra has noted for the financial solvency is no ground or denial of the claim of compassionate appointment in light of the provision in NCWA. In view of the discussions above, the impugn order is set aside. Respondents are directed to grant compassionate employment to the applicant as expediently possible within a period of 4 months, such and such. The division bench judgment against this order, my lord, they preferred SLP, my lord.
Dismissed.
Dismissed.
Yes.
Now, another judgment, my lord. Division bench judgment of this court. Here, my lord, the compassionate employment was directed to be provided with retrospective effect. With retrospective effect. 2018, volume 2, CLJ, page 219.
2018.
2 CLJ 219. This is also against the Eastern Coalfield Limited, my lord. This is also against the Eastern Coalfield Limited. Here also compassionate appointment has been declined and division bench directed, my lord, kindly come page paragraph 31. Paragraph 33. However, the grant of 25% wages in favor of the petitioner respondent from the date of medical examination completed is set aside. The compensation appointment be granted from his rejection 2008 with benefits as per her interment from such date. Formalities including the issue of letter of appointment in favor of the petitioner respondent be completed within a period of 2 weeks from the date of receipt of this order. So now, my lord, the compensation appointment was allowed since 2008 along with all benefits, and this judgment was decided in 2018 after 20 years. No, 10 years.
Has finished. First of all,
You first
I will
deal with the judgments.
I will deal with the judgments, my lord. I will come because first of all, my lord, I was about to deal with the judgments first because each judgment is to be seen from the perspective and the facts and circumstances of each case, whether the facts or circumstances are same or not. Because unless and until because all the judgments, as Mr. Ghosh has referred, does not lay down any ratio, as rightly pointed out by your lordship. It's not a 141 order.
No,
Judgment.
of course it lays down. It says that this is not a mere scheme, it's an agreement, result
Very
of
well,
an
very
agreement.
well. I will give another. I will
binding.
give another judgment, my lord. It's a 2018 reported, 2019 reported judgment. What is done, my lord? With all the due respect, my lord, every matter of compassionate appointment comes under a scheme. Here, the only difference is the scheme is a bipartite settlement, as your lordship knows. Nothing, no more difference there. Otherwise, in other matters, there is an unilateral scheme.
No. The moment it is a product of an agreement,
That's
it
why,
is
my lord,
binding.
It's always binding. It's always binding. If it is an unilateral scheme, suppose today, my lord, I set an example for myself. I am the employer. I lay down a scheme. I cannot go away or run away from that scheme. I cannot say I will not give effect to that scheme. Here also, my lord, it is binding upon both the parties equally. So, first of all, my lord, it is to be seen. I will come to the judgments, my lord. Whether, because, my lord, what I have learnt, my lord, subject to correction, that if the statute is not ambiguous, where the statute is ambiguous, then comes the judgment. Judgment comes
Here, no
later.
question of statute.
Here, my lord, it has got a statutory flavor. If it is taken to be so. So, scheme, I take it the statute means I substitute it by the scheme, that the NCWS as the settlement. But first come to what he has prayed for, because this is not a female dependent. Turimundi is a male dependent. So it's not a female dependent. Whatever judgments he has shown, it's regarding the female dependents.
Yes.
Female dependents. It's a male dependent.
Achha.
So 9.5.0 will not come into
The
play.
scheme does not apply.
No, scheme applies.
For compassionate appointment.
For compassionate, the scheme NCW is both for male and female dependents. But for female dependents, it's 9.5.0. Because it starts from 9.3.0, which says for each death or death of each employee during his employment, one employment will be provided. Thereafter, it clarifies the procedures or how or who. Now, death and, my lord, retirement by way of medical unfitness. Now, thereafter, it clarifies. So, whatever the judgments he has cited, my lord, first I will share that those are regarding female dependents. They are the female dependents made the claims. They were not given or rejected, whatever it is. Here the case is not so. So 9.5.0 is not attracted. This is the first one.
Show us the scheme.
Yes, my lord. Scheme.
Provision.
First, I show you a lot.
For male dependent.
My lord, just extract, my lord. If your lordship takes up from 1, 2, 3, NCW 6, 4th page. This is the social security scheme. That is under the NCWA. Now, my lord, 9.3.0. Provision of one employment to dependents. Employment would be provided to one dependent of workers who are disabled permanently and also those who die while in service. Now it says the provision will be implemented as follows. So thereafter, the provisions which are contained in this scheme are for implementation of the provision as laid down in 9.3.0. Now 9.3.1 says employment would be provided to one dependent of workers Now, my lord, 9.3.2. Employment to one dependent of the worker who dies while in service, Now, after 9.3.1, they divided into two categories. First, one for death, another for permanent disablement. Now, it's our case is covered by death. Insofar as female dependents are concerned, their employment payment of monetary compensation would be governed by para 9.5.0.
So leave 9.5.0.
It's solely for the female dependents. Now, I will come once to 9.5.0 to show one provision. Now, my lord.
To show with the male dependent.
Yes. Thereafter, my lord, I skip 9.3.3. It just gives the definition or the who would be the dependents. Obviously, son is a dependent. But not only, but why this is 9.3.3 says that he should be a son or wife. Not only that, and he should also be dependent on the earnings of the deceased. Whatever it is, my lord, son is a dependent. Now 9.3.4. The dependents to be considered for employment should be physically fit and suitable for employment and aged not more than 35 years, provided that the age limit in case of employment of female spouse would be 45 years as given in clause 9.5.0. Insofar as male spouse is concerned, there would be no age limit regarding provision of employment. Now, my lord, I skip. This is the provision for employment to male dependents.
Male spouse.
So, he's a son, he's not a male spouse. He's a son.
How can he be a spouse?
That's why I'm saying, my lord, he's not a son, he's not a male spouse. I have read out the provision only. So far, male spouse is concerned.
Yes, all right.
Now, my lord, I skip 9.4.0. So, up to 9.3.4, it contains the provision for providing employment to a male dependent. Now, 9.4.0, my lord, it's not applicable here in this matter, my lord. It is in case of who is permanently disabled. Now, 9.5.0, it deals entirely with the female dependent.
Not required.
Now, my lord, kindly consider. I must say, I must be candid with your lordship. It's my duty to show only one thing, that 9.5.03, in case of death, either in mine accident or for other reasons, or medical unfitness under clause 9.4.0, if no employment has been offered and the male dependent of the concerned worker is 12 years and above in age, he will be kept on a live roster and would be provided employment commensurate with his skill and qualifications when he attains the age of 18 years. During the period the male dependent is on live roster, the female dependent will be paid monetary compensation as per rates at paras 1 and 2 above. This will be effective from 1/1/2000. So, where there is a male dependent who is between the age of 12 and 18 years.
12 and 18. He shall be placed in the roster.
It's the duty of the employer to do it in the roster, and upon his attainment of 18 years, he is to be provided with employment, and till the time he is in the roster, the female dependent
will get the monetary compensation.
That's the provision. Here, the case is not that. It is not the case that he was 12 years, between 12 and 18 years, all these things. It is not the case. So here what happens, my lord, if my lord, he has not shown the dates. He has said that died in 1998, as rightly pointed out. When did he make an application? Nothing. What we could find from the records, because it's an old case.
Show me from your report.
From the report, my lord, what we could find that it may be at the best in 2012. Because, my lord, if your lordship takes up, because when they apply, a claimant applies, there are certain formats and they have to give an indemnity bond and all these things. Now, if your lordship kindly takes up page 15 of my report, this is the affidavit of Turimunda. He writes, I, Sri Turimunda, son of late Shadan Munda, aged about 34 years at that point of time when he made that application.
So 18 to 18, but 12 to 18 will not apply.
Not, no, 12 to, that I will come. At the time of death, he was above 18.
That's right.
Because I have the service experts, which I have also annexed.
To a 2012, this affidavit was affirmed.
Death in,
When he was in 34.
death in 1998.
1998 means 12 বাদ দিয়ে 14 বছর বাদ দাও 14 বছর
20 years.
24
According to him, this declaration, he was 34, 20 years.
so he's no way come within the purview.
Now, so first of all, my lord, I would like to show, my lord, from 98 to, he has shown that certain documents saying it to be 10 of 2010. First of all, the copies supplied to us, it's only black, my lord. It's, I cannot read it out. And thereafter, I have points to argue on that. Now here, my lord, first it is shown, because he has no documents to show when he has made an application. Now here, my lord, first it appears from this, my lord, kindly see the date when it was notarized, my lord, 17th April 2012.
That's why I said when he was 34 years. So if you deduct 14 years, it comes to 24.
24.
He is far above 18.
Far above 18. And second thing which I wanted to indicate, my lord, here. So from 98 to 2012, no explanation.
Forget it. Even if there is explanation, he is far above 18.
Far above 18. No, I say that on the other grounds, what he was saying, that yes, not this ground, but for a...
If he is not eligible at the threshold to avail of the scheme.
No, my lord, here, my lord, one difference. 9.5.0 is comes only when there is an when the male dependent is between 12 and 18. But even if he is above that, he is entitled under 9.3, 9.3.2. That. But even going by 9.3.2, now the question of delay crops up. Delay is there because the basic tenets of compassionate employment cannot be washed away. Whatever the scheme may be, that cannot be washed away. In Subodra, what he has cited, the case was debated.
that clause.
Yes, I am citing one after another, my lord.
No, show me first that clause. Or 9 point.
That clause, my lord. Again, my lord.
Point কত বললো?
9.3.0. It starts from 9.3.
No. That even after 18 he can.
No, even after 18, my lord, under 9.3.2. 9.3.2. And 9.3.3, because it's an enabling provision, my lord. My lord, kindly see provision of employment.
One second. 9.3.2.
It starts from 9.3.0.
হ্যাঁ 9.3.0 হয়ে গেল, then 9.3.1 employment would be provided to one dependent of workers who are disabled permanently. This is not your case. And also those who die in service. This is your case.
This is the case.
The provision will be implemented as follows. Employment to one dependent of the worker who dies while in service. Insofar as female dependents are concerned, their employment payment of monetary compensation would be governed by 9.5.0.
Yes.
That is for female.
That is for female.
Then 9.3.3. The dependent for this purpose means wife, son.
Yes, son. He is covered. He is a
Yes,
son. He is
admittedly.
Admittedly, thereafter 9.3.4. It prescribes the maximum age.
The dependents to be considered for employment should be physically fit and suitable for employment and aged not more than 35 years, provided that the age limit in case of employment for female spouse will be 45, as given in ATO. Insofar as male spouse is concerned, there would be no age limit.
Yes. There would be no age limit. So,
35 years as on when?
35 years is not. My lord, it should be as on death. Should be. But there should be a stretch. Why? If someone does not come, because basic, I repeat, my lord, basic tenets of compassionate appointment cannot be washed away. Someone waits for 10 years, comes, allows the years to pass, and allows his age to be more than 35 years. I ask myself, can I give? No. The answer is no, I cannot give. Because it says, it has two parts. No employment can be provided if you are more than 35 years. The first part is
come
this.
on the next day. আসুন। এগুলো রেখে দাও। হ্যাঁ, এই সব কটা একসঙ্গে কভার ফাইলে Mr. Partho Ghosh, learned advocate, appearing for the petitioner, has concluded his submissions. Mr. Manik Das, learned advocate, appearing for ECL.
Yes, madam. All the respondents.
And other appearing for respondents / ECL, has commenced his submissions. Poster. He shall continue on the next day.
I will reply to his submission.
Of course,
That you will get, definitely you will get.
after paragraph, after Mr. Das concludes, Mr. Ghosh shall reply only on the point of law. The writ petition shall appear under the heading court application on August 28, 2025.
Before your lordship rises, my lord.
Sir, this is not the time for mentioning, sir.
No, not mentioning, my lord. As is item number 4, my lord. Next, my lord, both of us are here, my lord. Can it, my lord, it's a joint prayer. Can it be taken up after a week, my lord? Item number 4, my lord. It could be adjourned for a week, my lord. This
After a week, it will not be possible because,
lordship is.
yes,
Oh.
so come after vacation.
Then lordship, let it remain as it is, my lord. Otherwise. Good night.